WPC number 10917 of 2018. Because of the interim order passed in this case, we are not in a position to complete the preliminary inquiry. Preliminary inquiry. There was an allegation against the opposite party.
Is it for final disposal or phase?
Pleadings are complete. It was for final disposal.
So you mention it next week. We felt the final disposal matters for this week. There are some judgments to be delivered. So please mention next week, next month. Okay.
This matter was in list last week for interim bill. It was delisted.
Please give it.
Another
Writ appeal number 676 of 2020. Here the appellants are on appeal since then.
No, is it a final disposal matter?
No, my lord, yes, sir.
Please you give it.
Yes, sir.
Give it.
I want to mention, my lord, item number 9. There is a connected matter which has to be listed along with this writ application. But the other case has not yet been numbered. Regular number has not been given. Perhaps you may call it after 2 weeks or after puja. It's for fresh admission.
Is there any stay order?
No, my lord, no stay. Item 9.
We are just adjourning at your instance, that's all.
Adjourn.
Arata file karibe se number hobo tapore mention karibe, that's it.
Again.
So the designation is
Senior panel comes.
Senior Panel Counsel, Mr. Vibhuti Bhushan Mishra, Senior Panel Counsel, 6 for an adjournment for 2 weeks. To talk this matter after puja holidays.
Quickly list item number 1.
And I am for the opposite party number 5, 7, and 8. The order of the Learned Tribunal has been challenged by
No, it's all right, but the 98 matters, nobody is appearing.
Anything survives?
No instruction. I have also not traced out my.
No interim order has also been passed in this case, as you find. It is just going on and on, but that's all. 98, at different point of time it was listed. And
For the state policy decision, they are scheduled caste, scheduled tribe, they are giving the promotion, and the petitioner, they are general category, they are claiming that we are not.
It's a reservation.
They might have all other issued
on appeals for the petitioner. The petition of the year 1990. Dismissed for enforcement. Yes, ma'am.
Item 2.
And 3 also you have filed the
Item 2, my
No
lord,
stay, nothing.
that matter, my lord, as per lordship, earlier order dated 1908, then 4, that double petition, let's come along with the double petition.
And you see what you are challenging. An order in which notice
That
has been
interim order, we challenge before this honorable court.
That must
There
have
is no
been
change.
That matter become infructuous in the
petition of
meantime.
the year 2000.
That interim order, as if there a final order, that's why that.
Against an interim order. So after going through this also, hearing the land, we find no merit in the writ petition, dismissed. Next.
Item 3.
Connected petition.
admitted and LCR has been called for. This appellant was left, my lord.
No, this is for, if an interim application is there for condonation of.
These are as well as for dispensing with this, because it is a application has not yet been admitted.
No, how much delay is there? 95 days. Is it a case where life imprisonment has been awarded or what?
Yes, yes, this is a case of 302 and 34 IPC. Life imprisonment.
Mr. Nayak,
My lord.
life imprisonment.
Life.
So we are condoning the delay.
My lord, before that, my lord, dispensing with the certificate, I have
This certified copy is available in which case?
connected fragment I have given
This CRLA 538.
538 and LCR has also.
All right.
Application number-
IN number 2351 of 2025. This is an application. But you have filed the Xerox copy.
Yes, sir.
All right. IN number so and so. This is an application filed for dispensing with the certified copy of the interim judgment of the London trial court. Mr. Jafrullah and counsel submits that in the connected appeal, that is CRLA number 530 2025, the certified copy of the interim judgment,
Free copy of the judgment.
a free copy of the judgment has been filed, and since both the matters are to be heard together, and the certified copy of the interim judgment be dispensed with. Land counsel for the land counsel for the state, considering the submission made by the land counsel for this one, so since the petitioner has filed the Xerox 2 copy of the interim judgment, and in the connected criminal appeal, the certified copy of the interim judgment, the free copy of the interim judgment is available, we will dispense with the filing of the certified copy. Accordingly, IA is disposed. Next is IN number 2350 of 2025. This is an application for condonation of delay in filing the criminal appeal. The stamp reporter has pointed out that there is delay of 95 days in filing this criminal appeal. After hearing the learned counsel for both the parties and perusing the grounds taken in the interim application, and since it's a criminal appeal in which the appellant has been sentenced to imprisonment for life, we are inclined to condone the delay in filing the appeal. Accordingly, delay is condoned, IA is disposed of. Hard admit trial court record is available in the connected CRLA. Therefore, the matters shall be listed along with CRLA number 538 of 2025 henceforth. Yeah.
Item 4.
May I please, your lordship? My lord, here against the acquittal order of acquittal, the victim has come up with your lordship challenging this appeal, my lord. Initially, we had filed.
These are Mr. Pradhan, you are also connected, no?
In connected appeal, my appeal has already been admitted.
How many persons actually faced that?
4 persons.
Oh. All the 4 have been found guilty.
Yes, yes, yes.
তাহলে এটা লিখি দিও খালি গোটিয়ে নম্বর মু ডাকিলি তাহলে এই যে সিআরএলএ নম্বর 723 অফ 2025 রে সেটা মধ্য কনেক্টেড হিকি না আসিব আর যে সিআরএলএ 90 অফ 2020 চারটা আকা আসিব অল ইয়েস item number 4 yes
Yes, ma'am. Ma'am, here the offense was under section 364, 366B, equal to 20134. FIR was registered by the mother of the victim. And here what has happened, my learned trial court acquitted the accused person only on the ground that the date which was mentioned by the informant and her husband, that is varying from the date of.
gang rape and murder,
Yes, ma'am.
so all of them have been acquitted.
Yes, ma'am. One was, my lord, never faced a trial. There was bit of trial.
No, in the last paragraph, that is paragraph number, last but one paragraph,
Yes, ma'am.
paragraph number 20,
Yes.
page number, internal page is 60 and running page is 76.
Yes, ma'am.
It is mentioned that I hold that accused so and so are
Yes, ma'am.
not guilty
Yes, ma'am.
of the so and so. So, it's a gang rape achi, murder achi.
Again.
Apart from 3 to B.
Yes, ma'am.
So, as it appears, these are the 2 persons who faced this particular trial.
3% are here, madam.
3%. 3%.
Yes, madam. Another is letter, but it has mentioned.
Acha, not guilty and acha, 3%, right. So, when this judgment was passed,
This one was passed when in the 2024, date is
Oh.
21st November 2023. madam.
okay, you have filed, you are the informant in this case.
Yes, madam.
We want the state to take instruction whether any, there is any proposal for filing the
Okay.
appeal against the order of acquittal, because it's a, there is prosecution case has been supported by the victims, that means the deceased family member.
Yes, madam.
Okay.
Offences, a series of offences,
Lekhando.
delay of 6 days.
Written.
Delay in content. Delay in content because when I file a lead petition, wrongly file lead. It's as 372, I can file directly criminal appeal.
But it is mentioned that 6 days billing. What is?
It is
On
content.
order raising.
My lord, that one was content by authoritative. My lord, 9/4/2024. 9/4/2024.
Limitation of 60 days report. Stamp report limitation.
नहीं स्टाम्प रिपोर्ट होगी 4 दिन देखे 6 दिन देखे
6 दिन.
हाँ एक डिले कॉन्डोनेशन को ऑर्डर देखो
Order the uploading.
ऑर्डर अपलोडिंग
My lord, I have copy, my lord.
हाँ दिस पास ऑन पास
9/4/2024.
अच्छा हाँ ठीक है 9/4/24 राइट है अलैकुम this criminal appeal has been filed by the informant in Govindpur PS case number 16 dated 14/2/2018 challenging the judgment and order dated 21st November 2023, passed by the Learned Ad hoc Additional Sessions Judge FTSC-1, Cuttack in Special GR case number 22/2018, which arises out of the aforesaid PS case in acquitting the 3 respondent, that is respondents number 2, 3 and 4, namely Rajesh Patnaik alias Bapi, Rajat Bhoi alias Kalu, and Sunil Pani alias Veda respectively, of the charges under section 264, so on, which was framed against respondent number so and so, and under section so and so, which was framed against the respondent number so and so. It actually page number 4, paragraph number 1 rege. These jonku gotte type ro charge is
Yes, ma'am.
aro jonku gotte charge is sir. So dekhi lekhi है ना. Let the learned counsel for the state obtain instruction as to whether there is any proposal by the state to challenge this impugned judgment. Put up this matter after a puja holidays also. Is this matter? We are keeping it on 13th or 15th of June.
What is the service position? Because there are a lot of orders
My
passed.
lord, notice was served, but they did not appear actually. During the time of filing application, leave petition, my lord.
15, 10, 20.
I see we have taken notice, my lord.
No, this, in this,
Many orders are passed.
issue notice to the respondent numbers 2 to 4. Press requisites filed. In the meantime, this is director sponsor.
The ex parte can't be heard. Bailable warrant has to be issued.
Requisites are filed, insurance of notice of that date. Yes, notice. Notice and transfer, sufficient here, and
Yes, my lord.
notice and transfer so sufficient.
Eligible water to show.
ঠিকঠাক করে সেটা ইয়ে করে দেওয়া।
Expert to put period, no?
হ্যাঁ?
This offense.
The board is sufficient.
Summons, they are not appearing. Now we have to choose NBW or eligible water.
So state of the instruction near Sile, we can do it. Then do now also, there is no problem. But
Valuable warrant issue with the state requires. Will issue valuable warrant.
Yes, that's.
See, the offense is very serious. You have to take instructions. I think.
but out of Paragon, since the আচ্ছা হার্ড অ্যাডমিট করবেন কারণ সিআরএলপিটা অ্যাডমিট এইটা এটা এটা অ্যাডমিট হবে সিআরএল হার্ড অ্যাডমিট ইস্যু warrant of arrest against the respondents number aforesaid respondents number 234 under section 390 CRPC তার provisionটা রেখে দেবো here so on and the inspector in charge of Gobindpur police station shall execute the warrant issued and produce them before the learned trial court, who shall release them on bail on such terms and conditions as it deemed fit proper, and with an undertaking that they shall take steps in appearing before this court in this criminal appeal, either in person or through their counsel on the next date, on the next date, which is fixed to 15th of October 2025. Pre-copy of the order be handed over to the land council for the state. The report, the land trial court shall submit a report regarding the appearance of the respondent number 224, through emails once. This order shall also be communicated by the registered judicial to the land trial court.
Item 5.
So this is on time. So it is to be, is that 302 case though?
Life.
Life imprisonment. So admit karigini, hey, serially prison though. For item number 6 also same. And no, for the least stage, the least to the joint PIG, repeat now. So please take just for a repeat over on the here.
Item 7.
May I plead with- And in this case, the present petitioner challenging the order at Annexure 1 and Annexure 26. On last occasion, Annexure 1 is the impugned order, and thereby during that the present petitioners are filing a review petition before the learned tribunal at Annexure 25. But in Annexure 26, the learned tribunal has rejected the petition on the ground of delay. Therefore, I have amended and that
You come to the order dated 13/2/25.
my lord.
ଆମର କୋର୍ଟ ଅର୍ଡର 13/2/2025 ଅର୍ଡର ଅଛି, କପି ଅଛି, ଦେଖନ୍ତୁ ସେଠି what
My lord.
13/2/2025
My lord.
ସେଠି ଆଭେଲେବଲ ଅଛି, ଦେଖୁନାହାନ୍ତି ପ୍ଲାଟଫର୍ମରେ ଦେଖନ୍ତୁ।
That petition has been filed by the Union of the
ବଡ ପାଟି ଟିକେ ପଢନ୍ତୁ।
My lord, this writ petition has been filed by the Union of India, represented through Secretary Minister of Statistics and Program Implementation, New Delhi, and the Direct National Sample Service Regional Office, Sambalpur, challenging the order dated 16/11/2023 passed by the London Central Administrative Tribunal, Kottagam in OA number 26095 of 2018, in which the opposite party Sudhikant Behra was applicant, and the learned tribunal has allowed the original application filed by the opposite party and held that the opposite party is entitled to be promoted against the vacancy calendar year 2013 instead of 2014, as has been given to him, and quashed the rejection order dated 17/1/2018, and the petitioner was directed to issue the consequential order within a period of 60 days from the date of receipt of the copy of the order. During the course of the argument, the learned counsel appearing for the petitioner submitted that against the aforesaid order dated 16/11/2023, the petitioner filed a review petition before the learned Central Administrative Tribunal, Cuttack, which was registered as RA number 260/4 of 2024, and filed order dated 27/2/2024. The review petition has been dismissed on the ground of delay and laches. However, in the writ petition, the aforesaid order passed in the review petition has not been challenged. Learned counsel for the petitioner seeks some time to file an interim application for amendment of the writ petition. Leave this matter in the week commencing from 10/3/2020.
Then you filed the interim application,
My lord,
it was allowed, then you filed the consolidated.
consolidated writ petition, my lord.
Okay.
And in the consolidated writ petition, my prayer is specific challenging the order at Annexure 1.
Where is that
the-
consolidated writ petition?
My lord, I have filed consolidated writ petition.
Now let us see your prayer in this consolidated writ petition.
My lord, my prayer at 16, my lord, at page 16 of the consolidated
Yeah.
petition. In view of the aforesaid facts and circumstances, it is most humbly prayed that this honorable court may be pleased to issue a rule nisi calling upon the opposite party to show cause as to why a writ in the nature of certiorari and mandamus
You
or
have
any other.
committed again the mistake, same mistake.
My lord.
We allowed this, then the review order should have also been mentioned in the prayer portion.
Sir, prayer 26 annexure ଅଛି review. That has been,
ଆପଣ କଣ ପାଇଁ ମାନେ ରିଭ୍ୟୁ ପିଟିସନ ର ଫାଇଲ କଲେ, ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଫାଇଲ କଲେ କଣ ପାଇଁ? ଯେ ରିଭ୍ୟୁ ପିଟିସନ ଟା ଭିତରେ ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲାଣି, ସେ ରିଭ୍ୟୁ ଅର୍ଡର ଟା ଚ୍ୟାଲେଞ୍ଜ ହେଇନି, ତେଣୁ ଆମେ ଆପଣଙ୍କୁ ଆଲାଉ କଲୁ। ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଆପଣ ଫାଇଲ କଲେ, ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଆଲାଉ ହେଲା। ଯେତେବେଳେ ଆପଣ କନସୋଲିଡେଟେଡ ରିଟ୍ ପିଟିସନ ଫାଇଲ କଲେ, ସେତେବେଳେ not only the order passed in the OA but also the order which has been passed in the review petition,
my lord.
both the things should have been mentioned. You have
Right.
not challenged it, that review petition order.
My lord.
Your review is
Yes, yes.
disposed of on 27
My,
to 2025.
my lord.
Have you challenged that?
Yes, yes, my lord.
Well,
My lord, that is my consolidated.
Full consolidated କିଛି
prayer
ଡାଟା
ଦେଖନ୍ତୁ,
My lord, that
consolidated prayer ଦେଖନ୍ତୁ।
my lord, writ application in judgment dated 7 passed in OA number ଏତିକି and annexure 26.
କୋଉଠି ଲେଖା ହେଇଛି?
କୋଉଠି ଦେଖନ୍ତୁ?
ସେଇଟା ବୋଧେ consolidated, ମୁଁ ତ consolidated.
ଆଉ କଣ ଫାଇଲ ଦେଖନ୍ତୁ?
Consolidated petition I have filed on 13/8/2025.
Page 20 ନା 16 ଥିଲା ନା?
16, my lord.
16 କୋଉଠି କଣ ଲେଖା ହେଇଛି? ରିଭ୍ୟୁ ପିଟିସନ ତ ଟୋଟାଲ ଲେଖା ହେଇନି କିଛି।
Repetition also.
My lord, I am filing this online.
So then you filed the wrong thing. 16 ରେ କିଛି ଲେଖା ହେଇନି।
13,
Judgment dated 16/11/2023 passed in OA number so and so.
No, ଏଇଟା ନା,
No, this is
This
something else you have filed.
ଏଇଟା ମୁଁ ଦେଖେଇଲେ, ଏଇଟା ସେପଟୁ କଣ ଫାଇଲ କରିଛନ୍ତି? ଏଇ ନାଇଁ, ଏଇ ପେଜ ଟାକୁ ସେପଟୁ
ଫେର କାଢନ୍ତୁ, consolidated end ରେ ଅଛି।
ଏଇ କନସୋଲିଡେଟେଡ ପିଟିସନ ଟା କାଢନ୍ତୁ।
End ରେ ଅଛି। ଏଇ ଜିନିଷଟାକୁ ଫାଇଲ କରିଦେଇଛନ୍ତି।
ଦେଖନ୍ତୁ ଆପଣ କଣ ଫାଇଲ କରିଛନ୍ତି, ଦେଖନ୍ତୁ।
ପୁରୁଣା ରିଟ୍ ଟାକୁ ଆଉ ପୁଣି ଫାଇଲ କରିଦେଇଛନ୍ତି।
ଫାଇଲ କରିଦେଇଛନ୍ତି, ସେଇଟାକୁ ଫାଇଲ କରିନାହାନ୍ତି କନସୋଲିଡେଟେଡ ଟାକୁ।
ପୁରୁଣା ରିଟ୍ ଟା 20/12/2024 ରିଟ୍ ଟାକୁ ଫାଇଲ କରିଦେଇଛନ୍ତି।
ପ୍ରେୟାର ଟାକୁ ଦେଖନ୍ତୁ।
20/12/2024
ହଁ ମୁଁ ଦେଖି ସାର୍,
ଗଲତି ହେଇଯାଇଛି।
ଆଗେ ସାଟିସ୍ଫାଏ ହୁଅନ୍ତୁ। देखिले कंसोलिडेटेड रिट ऑफ प्रेयर टा देखिले अरे से बसी जाउजी कोन पे
ये 16 काढ़
କିନ୍ତୁ but this is my petition and
आपण फाइल कला बना आपण पाके सेडा थिले रही थाउ आमे आपण कहलु कंसोलिडेटेड रिट पिटिशन आपण जो रिट टा फाइल करते पुनी आउ थरे फाइल कर देले यू फाइल द कंसोलिडेटेड रिट पिटिशन
आपण एटा फाइल करचंती
my lord this is
प्रूफ देखांतु हमर स्कैनिंग रे खराब ही देबो
this man
प्रूफ देखांतु फाइल कर स्कैनिंग डॉल फाइल कर so as the proof that you have filed this consolidated
এটা ফাইল করতে দেখি অনলাইনে जो ফাইল করতে তার প্রুফ প্রুফ তো দেখ
आदेर लेखा है मेमोटा आपनकर होउची 12/8/2025 रो बुझिले आदेर लिखिले as per the direction of the honorable court on 14/7/2025 in the aforesaid writ petition the petitioners are filing the consolidated writ petition for the interest of justice है ना से या लिखिले किंतु पुरानाटा फाइल कर देले फाइल दी कौन लिखूं it appears that even though the petitioner was supposed to file the consolidated writ petition and in the memo also memo dated 12/8/2025 which is signed by Mr. Manoj Kumar Pati, Learned and Senior Panel Counsel, it has been mentioned that as per the order dated 14/7/2025 of this court, the petitioners are filing the consolidated writ petition, but the writ petition which was filed along with the said memo is not the consolidated writ petition, but the old writ petition, but the writ petition number so and so prior to the amendment. So, yes, Pati Learned Counsel submits that he may be given some time to file the consolidated writ petition. Put up this matter on such and such date. Consolidated writ petition be filed in the meantime. Yes.
my lord today in course of the day I am filing
फाइल करंतु फाइल करला परे मेंशन करिवे तापरे आउथर लिस्ट आसी हला यस
Item 8.
आपण देखि नांती आपनकर बस डीलिंग असिस्टेंट जे भी हो से पुरानाटा फाइल कर देई छी मेमोटा नुआ देखला बळकु यस
It is not that order of ombudsman under Annex 4 is under challenge miller. Your lordship is directed me to go through that case in case miller. Lord, I have gone through that miller. That is altogether in the separate filtering. That is the transfer relating to transfer of land to the purchaser, and the liability of the purchaser is decided there miller, taking into account the summary case miller. That is the property put in auction, whether the auction purchaser liable to pay or not.
a detailed order was passed when it
subsequent order करें स्कैनिंग करेंगे
2023 SCC 14
detailed order
तीन इन ऊपर आउट ऑर्डर सेकंड ऑर्डर
and so far my case is concerned, my lord. Here is the landowner.
September 2025
Actually, sir,
there was a detailed order passed in your case.
yes.
Do you have that order
Your
with you?
lordship observed that I
Yes.
don't have that decision on that date.
Yeah.
So your lordship directed me to
Do you have that order with you?
say that.
we passed the order and we dismissed your case on that day same point was raised
Milord, that is altogether a separate.
I beg your pardon, Lordship.
So will be
If
decided there.
Lordship grants me some time, I'll opt in the order that Lordships have passed.
That, I think previous week.
Yes,
you
Lordship. Yes, Lordship.
Out of this matter, day after tomorrow. Patna. ठीक है ये order का conference ऑनलाइन स्कैनिंग करियो एक ऑर्डर स्कैनिंग ही जो रहेगा प्लस आज जो ऑर्डर है ना नेक्स्ट
Item 10.
May I please your Lordship?
opposite person
May I please your Lordship? Lordship, I'm audible.
yes
Lordship, I'm the petitioner. Petitioner is the guarantor, your Lordship.
what you are challenging
I'm challenging possession notice dated 4/6/2025 under Annex 7.
go to the DRT why are you
Dispose-
challenging here
Your Lordship,
Possession notice.
please dispose with liberty to file under Section 17.
Second, the petitioner has, who is the stated to be the guarantor, has filed this writ petition challenging the possession notice dated once under Annexure 7, which was passed under the provisions of the Surface Area. Opposite distance would have been liberty granted to dispose of it. Yes, next.
So blessed, your Lordship.
Item 11.
My lord, item 11 on behalf of Mr. G.K. Nayak, my lord. Matter may come after provocation, my lord, will file rejoinder in.
No, but till date, your Lordship, I am appearing for the respondent, Lordship. Till date, matter has not been admitted, your Lordship.
Till then,
Matter has not been admitted, your Lordship, so that.
no, it's all right, but they have already filed a reply, I think. Some caveated, acha.
11, your Lordship.
You are for the caveated.
Yes, your Lordship. Face admission.
He is right, this matter has not been admitted, but all the same, you have filed your reply.
Yes,
So they want a response to your reply. You have received the reply.
My lord, sir.
What has been challenged here? What you are challenging
The
here?
order of the tribunal, ma'am.
Order dated 9/5/2025.
Do you have the file with you?
I apologize, my lord, I just received the instruction.
You may file.
So the mention is made by so on behalf of Mr. Krishna Nayak for adjournment. This matter after Puja holidays.
May I pray, your Lordship? Lordship, this is a
And
matter for
counsel for
pension.
the opposite party number. You are appearing for
The
the
both opposite party, your Lordship.
for the opposite parties. What is your good name?
My name is Jyoti Ranjan Behera, J.R.
Mr. J.R. Behera is present. Hello? It will come after Puja holiday. Yes, next.
Lordship, let me fix a date so that. Other-
In the evening, you will find the date.
Oh, yes.
That is the court master used to see that how many cases can be posted on which date.
Yes,
So
sir.
if we fix it now, right now, it will be create difficult. He has to see the diary and accordingly fix
Yes,
it,
sir.
right?
Yes.
Item 12.
I will please your Lordship.
Yes, for the petitioner challenge the order under Annexure 1. Passed by
Mr.
the-
Jena, you are
I am
the cavator in this case.
Cavator, sir.
You have received the copy of the
Yes,
petition.
fine.
Yes.
The challenge the order dated 19/12/2024
passed by the Central Administrative Tribunal Court of Bench in OA number 339 of 2020.
14 applicants filed that way.
14 applicants filed that OA,
And
and the
they, what was the nature of
the nature, my lord, they are demanding a scale of pay during the training period.
they were all BSc with mathematics.
BSc with mathematics, they are now working as a surveyor. They are at the applicable scale of pay. But during the training period, for which 2 years were their training period, they were selected as TTA.
No, the issue is whether they are similarly situated with the applicant of the Bangalore CAT.
Well, Bangalore CAT,
Bangalore court, there is an order.
there is an order. Well,
That
that order,
and finality.
yes, sir, that order.
Court says that they are covered by that. You have to give it. Come to page 32, para 6.
Para
6 and 7.
my lord.
Para 6 just see.
Para 6, my lord.
Page 32.
Para 6, 5.
Okay, 5 we want to place.
Yes,
Please,
Five
please,
also reading.
please, please, paragraph 5.
Para 4 onwards, my lord, I will place.
Okay.
It is noteworthy that once a decision has been taken by a higher competent court of law on a particular issue for a particular group of employees, the respondents are under obligation to implement the same and cannot take the stand that the said decision of the competent court was implemented under duress, compulsion, exertion of contempt of court and due to non-availability of further legal course as the SLP was dismissed in limine. That was, my lord, under duress that order was implemented. That was the stand taken by the present petitioners. Para 5, my lord. It has been laid down as a norm that when a particular set of employees are given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not extending such benefit would attract vice of discrimination and thereby the action of the authority would be arbitrary, being violative of Article 14 of the Constitution of India. It has also come to be observed that in case of judgment in personam, though it has no application, but on such pronouncement, it becomes an obligation on the part of the authorities to extend the benefit to all such similarly situated persons, except the person so approaches shall have to satisfy that their particular request does not suffer from either laches and delay or acquiescence. In deciding the case of State of Karnataka versus C. Lalitha, reported in 2006-2 SCC 747, Honorable Apex Court has come to observe that service jurisprudence evolved from time to time postulates that similarly situated employees should be treated similarly. Merely because one person approached the court, that would not mean person similarly situated can be treated differently. It is for the above consistent view of the Honorable Supreme Court of India, this court finds the State of Odisha model employer has no escape from applying the principle decided in the case of Ritanjali Giri alias Paul versus State of Odisha 2016-1 ILR Kotak 1162 to all such similarly situated cases. Such a view has been expressed by their courts in Prashant Kumar Mahapatra versus State of Odisha, WBC such and such, that judgment dated 28/9/2021. It was held by the Honorable Apex Court in Inderpal Yadav versus Union of India, such and such, held that the relief granted by court is to be given to other similarly situated employees without forcing them to go to court for similar benefits. The same view was expressed by the Honorable Apex Court in the case of Lalberi versus CE 1975 4 SCC 714. An employee cannot be treated differently vis-a-vis other similarly situated employees, as has been held by Honorable Supreme Court of India in case of Union of India versus Satyabrata Chaudhary 2009-2 SCT 365. It has also been held in division bench judgment of this court in Balraj Singh versus State of Haryana 2009-1 SCT 589 that once a controversy has been settled by the court, final judgment is required to be implemented to all employees similarly situated. The final and ultimate finding is, it is not in dispute that the applicants are similarly situated employees like the applicants before the CAT Bangalore bench, Honorable High Court of Karnataka, which order was upheld by the Honorable Apex Court. Therefore, we are of the view that once a view has been taken on a particular issue of a particular set of employees working in Bangalore, the employees working in Odisha in the same department are entitled to the benefits what has been granted to them. Hence, the impugned order of the rejection dated 19/6/2020 is hereby quashed, and the respondents are directed to grant the similar benefits as has been granted to the applicant before the Honorable High Court of Karnataka by the order dated Karnataka at Bangalore, WPC 39163, 39165 by 2013, SCAT within a period of 90 days from the date of receipt of copy of this order. But my humble submission is Bangalore High Court's judgment is not binding, my lord, on this honorable court. And while passing the order, the Bangalore High Court.
Now you have taken a stand that duration. Come to 202, page number 202, your counter, para 15. This is the only stand you have taken. How can you take this stand like this?
Well,
The SLP is dismissed. And then you say the duration. What duration?
That stand, my lord,
That is the main reason why the litigations are on rise. That is the reason why there is docket explosion. Once you know that, yes, if a particular person has get the relief in the factual scenario of that particular case, the matter is different.
Yes.
Okay, you can say that the order has been passed, that it will not be a precedent. Matter is different. But when similarly situated, same department, the relief has been granted and it has been upheld by the Honorable Supreme Court. Now you are telling that no, that has been passed by Bangalore bench, Karnataka bench, and
See the reply 202, page 202 counter. Para 15.
Your lordship, allow me, I will.
See, this kind of stand has to be, this
That-
reprehensible.
that-
Apprehensible.
That is disgraceful.
You are imputing motive against the court. How can you make this statement?
I have
Duration, contempt. You have not complied. The contempt proceeding there.
ordered,
And
my lord.
as if the court is forcing you to do it. But
That
read
is-
it. Your stand.
Yes, but that is disgraceful. My lord. I
On
have
the
gone
face of
through
the
it.
stand, with exemplary cost, it has to be dismissed.
My lord,
judgment has been pronounced, it has been upheld by the Honorable Supreme
You
Court.
have to have
And you are-
respect to that order.
What is this
That is-
type of?
that
Let's
is-
see, read it. Read
Yes,
it
my lord,
loudly,
I have-
then you will find.
I have gone through it, my lord.
How
That
this
is not
counter is-
graceful. That I have
You are mentioning
marked,
that
my
the
lord.
High Court has passed the order under duress one.
Yes, my lord. That is
What is
the
this?
stand.
What language is this?
That should not have.
Duration, compulsion.
My lord,
Which court is compelled you? Your union affidavit?
no, my lord, that is not. That should not have been. That stand should not have been taken in their account.
This type
No,
of-
I bowed down.
Please,
The deponent is liable to contempt, so he has escaped, it's all
Well,
right.
my humble
You
submission.
should be
your
happy
lordship-
that the court has not taken it seriously.
Well, my humble submission, your lordship may kindly consider.
Sorry, the writ
The
petition has
scheme
been
of
filed
the
by
circular has
the-
completely been
by the
ignored, my lord.
Central Administrative Tribunal, Cuttack Bench, dated so in way number so. It appears that the opposite parties filed the original application before the London Central Administrative Tribunal with the following relief. Hala? You quote the relief sought for. It has been mentioned in paragraph number 8 at page number 57. The petitioners entered their appearance and filed the counter affidavit. And in
No, may I pray, my lord, that may not be
Parag-
taken note of because that will create problem for the
This-
counsel who is conducting the case in the tribunal below. And that will create a problem for him.
And
Otherwise,
what you are writing, due to non-availability of the further legal course, and as a SLB is dismissed.
my lord,
And durations and.
I bow down, your lordship is very correct, my lord. There is no.
They filed the counter affidavit. The London Tribunal, after hearing the London Council for both the parties and considering the submission, has been pleased to hold as follows, quote paragraph number 5, 6, and 7. On perusal of the impugned order, it is clear that similarly situated person like the opposite parties have already got the relief in the
Haven't got the relief, my lord. They have been directed to
before the Central Administrative Tribunal Bangalore bench, in the Honorable High Court of Karnataka, and it was upheld by the Honorable Supreme Court. There is no dispute that the petitioners are similarly situated. Therefore, the London Tribunal is quite justified in considering the propositions laid down in the aforesaid cases and came to hold that the opposite parties are entitled to get the benefits, and accordingly was the order of rejection dated 19/6/2020 and directed the petitioners to grant similar benefit as has been granted to the applicants before the Honorable High Court of Karnataka by WPC number so on so. We find, after hearing the Land and Council for the Union of India, so also the Land and Council for the opposite party, Mr. Jena, we find that the reasonings are quite justified and there is no infirmity or illegality in the same to be interfered with. Accordingly, the petition being devoid of merit stands dismissed. Yes, next.
Item 13.
The petitioner has challenged the order of the Honorable Central Legislative Tribunal, my lord. Number 58, my lord.
Yes.
The Honorable Tribunal held that arguments advanced on behalf of the petitioner are that this being matter relating to family pension comes under the recurring course of action and therefore delay is liable to be condoned. We find this summation merit acceptance where the grievance is in respect of payment of pension as such amount becomes due and payable such each month. Rather, this tribunal cannot go beyond the provisions of Administrative Tribunal Act and the law that an applicant who approaches the court relatedly or in other words sleeps over this his rights for a considerable period of time, wakes up from his deep slumber or not to be granted the extraordinary relief by the court's tribunals on the basis of the specific decision honorable acted for that delay defeats equity. Delay or laches is one of the factors which should be borne in mind while exercising the discretionary powers by the court and the tribunal. In the instant case, the applicant admittedly approached this tribunal after 29 years of the death of the railway employee without any such unimpeachable documents to establish that her husband was working in pensionable establishment. She has produced Xerox copy of the bank account to show that after the death of some amount was credited in the said account, on perusal of which it is not visible whether where from such amount was credited and from what purpose. Therefore, this document cannot be accepted at this place of time to come to the conclusion in absence of any such supporting material that she was the wife of late Paidhar and was entitled to family pension. This tribunal cannot make a being inquiry as to come to the decision that conclusion that the applicant is actually the widow of the employee and is entitled to family pension at this stage when it is specific stand of the respondent that
got those decision that non-payment of this family pension by the authorities is a continuing cause of action. That is the main point because you have approached the tribunal after 29 years.
Well, it's,
You are the wife of the
is
deceased person and you have not been.
she's a illiterate lady, my lord. She's illiterate.
You see, the cause of action arose 29 years back. Your husband
Yes,
died.
yes, yes, no.
You should have filed the application within the
Well-
stipulated period.
She was not aware of his legal rights, my
The
lord.
council, we are hinting you at something. You are not catching it. Non-payment of the family pension is a continuous cause of action. So in such circumstances, the court cannot deny it on the ground that he approached the court late. Have you studied this?
Yes, no.
What is the ratio? What is the citation?
That's my lord.
Anna?
Limitation, continuing wrong, recurring or successive wrongs, different explain. Continuing wrong is a single wrong causing continued injury. Recurring or successive wrong on the other hand,
This is a case of pension.
yes, ma'am. Service matter,
Disability pension.
Disability. There are other cases also. You find out some other cases are
yeah,
there.
my lord, I'm placing one judgment SK Mustan P.
Awesome.
That is the case. Nearly.
Relevant portion of parliament.
We notice that it was second page. We notice that
Second page of whole line,
circular.
last paragraph.
No, first. 1, 2, 3, 4, after 4.
Fourth paragraph, fourth line.
Fourth line, man.
We noticed that, yes.
We noticed that the applicant's husband was working as a gameman who died while in service. It is on record that the applicant is an illiterate who at the time did not know of her legal right and had no access to any information as to her right to family pension and enforce such right. On the other hand, the husband of the applicant, it was obligatory for her husband's employer, railway, in this case, to have computed the family pension payable to the applicant and offered the same to her without her having to make a claim or without driving her to litigation. The very denial of the right to family pension is as held by the land single judge, as well as the division bench is an erroneous decision on the part of the railway, and in fact amounting to a violation of the guarantees assured to the applicant under Article 21 of the first one. The factum of the applicant's lack of resources to approach the legal forum timely is not disputed by the railway. Question then arises on facts and circumstances of the case. The appellate judge has justified in restricting the past years of pension.
They are the two
This
decisions.
High Court election, my lord, in another in the matter. We also consider it appropriate to state that
Yes, yes. Ma'am.
third page,
Which paragraph?
third page.
Hmm.
We also consider it appropriate to state that when a technical question is pitted against a substantial question of law or substantive question of imparting justice, then substantive consideration should not be weigh the technical consideration. A meritorious matter should not be decided on the question of a limitation when the petitioner approached the court after some delay, but there is some reasonable cause which prevented him from coming to the court.
You have here 29 years.
All right, take down. This writ petition has been filed by the petitioner, Purki Mohanto, alias Purkia Mohanto, challenging the order dated 1/8/2024, passed by the London Central Administrative Tribunal in MA number 260/0002 of 2024, which arises out of OA number 260/0004 of 2024, order dated according to 1/8/2024. In dismissing the miscellaneous application and consequently the original application also. The petitioner filed the original application with the following relief, or the relief sought for, and the same is available in paragraph number 8, internal page 10 and running page 26. The miscellaneous application was filed. ए मेरा कॉपीटा ଦେଇଛନ୍ତି?
It's 42.
Is it?
42.
The miscellaneous application was filed, which was numbered as MA number 2 of 2024 for condonation of delay under section 21(3) of the Administrative Tribunal Act, and to adjudicate the original application on merit. The opposite parties filed their objection to the application.
40.
And contended that there is inordinate delay in approaching the London Tribunal, and no justifiable explanation has been offered by the petitioner for such condonation of delay, and therefore it is not condonable, and therefore the miscellaneous application and also the original application should be dismissed on the ground of delay and laches on the part of the petitioner. The London Tribunal has been pleased to head as follows. Quote paragraph number 13. The Land Council for the petitioner placed reliance in the case of Union of India and others versus Tarsem Singh, reported in 2008 and Supreme Court cases 648. So also in the case of SK Mastan B versus General Manager, South Central Railway and another, reported in 2003 SCC bracket L&S 1993, wherein it has been held that that non-payment of the pension amount is a continuous wrong causing continuing injury and though the service matter claims normally rejected either on limitation, where limitation period is prescribed, or on the ground of delay oblique laches, where there is no limitation, but there is an exception to this principle to the cases of continuing wrong, which can be entertained despite delay. However, this exception does not apply where the interest of a third party, as in the case of seniority or promotion, are affected. In the case of Tarsem Singh, which was a case of disability pension, and in the case of S.K. Mastan, which was a case of Raki case, which is also case of family pension, the reliefs have been granted even though there was delay or substantial period. Issue notice on the question of admission indicating that the matter shall be disposed of at the stage of admission. Land Council for the Union of India accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the so and so. Within a week, you put up this matter. 4 weeks for it for counter affidavit, if any, will be filed in the meantime. Yes. This only one.
Item 14.
Soumya Mishra. What is this writ petition, Mr.?
They have to vacate the auction process property.
Surface matter.
Surface matter. There is auction purchaser.
So-
Auction was settled in his favor. Auction was settled in his favor and
Okay.
clear.
Why he has come to this court?
Oppositor shall not be direct to release the entire auction amount deposited the petition with the administrative interest. Taking over the.
No, he is playing quashing of annexure 14.
Again,
What is that? It was order passed by the collector.
yes. Then 14 was allowed to take over possession by the bank to handed over the auction.
Order to top February in Kono.
Up to annexure 14.
Annexed is the order of the collector. Collector directed to take over possession by the bank.
And
with the
hand it over.
assistance. But the auction purchaser is not able to, the bank has not taken over possession.
It is not refund that amount.
যেহেতু সে অকশন অ্যামাউন্টটা জমা করছি অকশন পজেশনটা পাউনাহাନ୍ତି তেଣু he has filed this petition for refund of that.
Achha. So the main grievance is against the bank.
Bank.
Which bank it is?
UCO Bank.
Nobody is appearing.
Item 15.
In this case, Union of India is the petitioner challenging the order dated 29/4/2024 under Annexure 5. Particularly CAT number. This petition has been filed.
Passed by?
the learned cat. Little Tiglath. And the applicant before the cat, he was an income tax officer. There was an inspection where in 35 out of 40 cases, it was found that he had shown undue favors to the assessees. Therefore, notice was issued.
What type of undue favor you mean to say?
Assessment order में किसी irregularity की ना सेटा से बोल.
But if it is found, if it is not deliberately, it may be that it can be the higher forum can be approached and it can be corrected. So can you take initiate a disciplinary action against a officer? Is a quasi judicial authority. So unless that it has been deliberately done to show the favor to the assessees, suppose some erroneous calculation has been made and it has been what is the finding ultimately?
Actually, to kindly see annexure 6 series, the first letter from the authority to the applicant. 6 series, page 218.
The
By the ADG Vigilance East. Usually RTI said.
no any like any criminal case has been instituted. No. So the decision of the Honorable Supreme Court has been relied upon that say
That the judgment of
there it has been held one case has also been relied upon that there the assessment order was passed by the applicant in the capacity as Assistant Commissioner of Income Tax. So
Any of the assessment order is set aside?
not yet.
Hmm?
then how can you
Then-
say that?
He was asked to submit a
This is a quasi exercise of quasi judicial power.
yes, ma'am.
Assessment has
No,
been
you
done.
have already initiated a proceeding. It's not a
The proceeding is quashed. Saying that you can't proceed.
On 8th of April 2021, he was directed to show cause, to submit a show cause. Thereafter, in the month of May, he filed the OA before the CAT.
You
And
see,
that culminated in the
today, you see just, today is the last date of ITF filing, income tax. And maybe today, maybe before one person, maybe 5,000 or more that is filed. So it is obviously he has to go through, but he accepts it, let us say. And in case it is found that there is any, that subsequently it can be also reopened because the period is there, na 3 years it can be. So in that way, suppose you have accepted it, he has accepted it. And if you find that the assessee has given filed a wrong return, let us say, and the exact thing has not been reflected. So it can be subsequently appropriate order can be passed and he can be asked also to deposit but you are initiating a proceeding against this officer on the question of deliberateness, unless you find it. So in some cases you say that it has been done. The assessee has not filed the correct return. It was accepted. But you cannot forget
If there are hierarchical remedies, you pursue those remedy, get it set aside, whatever. But how departmental proceeding? It may be a judgment error.
On the basis of the vigilance report only, they proceeded, ma'am. So
No.
they vigilance
We
proceeded.
can't stop vigilance
with the
report.
inspectors.
yeah, that is why exactly we asked. Suppose you would have been held up in a draft case like that for accepting such things, or any disproportionate asset case, matter is different. But that is why we asked him that whether there is any other type of cases.
No, ma'am.
So if that is not there, so
The only thing is that for three financial years, 2016-17, 17-18, and 18-19. For 3 financial years, there were some irregularities. Vigilance inspected the cases, taking the permission of his authorities, and it was found out.
according to you, the assessees have not filed the correct returns. Yes. Okay. Or suppose, let us say income tax returns were filed and they were liable to pay taxes. It was not shown. And in certain cases, you have detected it and it was also accepted as such by the person. But unless you prove, when my esteemed brother is pointing out that in the hierarchy, the order can be that can be reviewed also, that and the SEC can be noticed that your return is not correct. They can, after the consideration, they can be asked also to pay the tax. But the person who has accepted it, maybe that it's a question of error. How do you say that he is liable to face disciplinary proceeding? That is the exact reason what has been held in those decisions which has been relied upon by the Land and Central Administrative Tribunal.
Is this whole case, my lord? Things 35 cases are there where they found irregularities and he didn't file an appropriate reply. He said that I don't remember what has happened by that time, so I cannot exactly say.
Obviously,
Exactly.
this man has already retired.
Yes, retired last week.
So now you will ask him that what happened in those periods. Kebe kare gudago?
2021.
Huh?
21 the proceeding है 2018-19 का financial year.
That man has already retired. When you initiated the
In
department?
the month of May 2021. And he retired somewhere October.
This is just a harassment.
And pertaining to the conduct in 2008,
18-19.
89.
And since he didn't give an satisfactory reply.
Look, this writ petition has been filed by the Union of India challenging the order dated 29/4/2024 passed by the Land and Central Administrative Tribunal, Cuttack Bench Cuttack, in OA number such and such. In allowing the original application filed by the opposite party and was the memorandum of charge dated 8/4/2021. The opposite party filed the original application before the Land and Tribunal seeking for following relief for the reliefs which are mentioned in paragraph number 8, page number 26. After issuance of notice, the petitioners appeared before the Land and Tribunal and filed the counter affidavit. And the opposite party also filed rejoinder to the counter affidavit filed by the petitioners. From the petitioner side, a reply was filed to the rejoinder affidavit. Stop. From the factual scenario, it appears that the opposite party was the retired income tax official completed the scrutiny assessment under section 142 of the Income Tax Act 1961 from the assessment year 2011 to 2016-17. But it is the case of the petitioners that the same was completed in a reckless and grossly negligent manner without proper inquiry and investigation with malified intention to favor the assessees. It was contended by the opposite party that in terms of the IT Act 1961, if the order of the assessment was in any manner wrong or illegal or was passed with malified, the same is reversible in exercise of the power under section 263 of the IT Act 1961. But no disciplinary proceeding can be initiated against the assessing officer in view of the provision under section 293 of the IT Act 1961. And therefore, the initiation of the disciplinary proceeding is against the statutory provision. Stop. Section 293 of the IT Act reads as follows. Quote further, no prosecution, suit or other proceedings shall lie against any officer of the government for anything in good faith done or intended to be done under the IT Act. The petitioner, the opposite party placed reliance on different decisions of the Honorable Supreme Court, where such initiation of disciplinary proceeding has been quashed. And it was the case of the opposite party that the charge sheet is not sustainable. And the proceeding with the inquiry will be nothing but a humiliation and harassment to him. The contention which was raised by the petitioners in the counter affidavit is that the opposite party was the Income Tax Officer Ward 2, Jharsuguda, and Income Tax Officer Ward 1 to Sambalpur during the financial year 2016-17 to 2018-19. And during these periods, he had passed assessment order in 145 cases, out of which Director Vigilance, Kolkata, with the approval of the DA, carried out inspection of 40 assessment reports and prima facie found that the opposite party in 35 cases completed the scrutiny assessment without proper inquiry and investigation. And it appears to be a reckless and grossly negligent on the part of the opposite party. Stop. The learned tribunal after considering the contentions of the respective parties and placing reliance in the case of Union of India and others versus K.K. Dhawan, 1993-2, SCC 56, So also other decisions would have relied. Held as follows. Ramesh Singh Guttachi, High Court of Allahabad, Ranchi. Held as follows. Quote from paragraph number 18 onwards, 18, 19, and 20. When we posed a particular question to the Land Council appearing for the petitioners, that whether any of the assessment orders of the petitioner was reviewed in before the higher authorities, the answer was in negative. We find that the Lenin Tribunal not only taking into the provision under section 293 of the IT Act, but also the ratio laid down by the Honorable Supreme Court in various decisions has came to hold that the petitioners were not justified in subjecting the opposite party to the disciplinary proceeding or the order of assessment passed by him in exercise of quasi-judicial authority as per the statute. The petitioner has retired in the meantime as submitted by the counsel for the petitioner. Therefore, when the Lenin Tribunal has held that the memorandum of charge is not sustainable in the eye of law, and was the same, and we find no illegality or infirmity in the impugned order, we are not inclined to interfere with the same. Accordingly, the writ petition being devoid of merit stands dismissed. You are Mr. Mahanti. What is your
CGC.
CGC, Central Government Council? Yes. Next.
The OP number 1 has retired.
Mhm.
That is the Indian opinion.
Sorry?
OP number 1 has retired.
OP number. Correct. We are correct.
Right.
OP. Yes. Coming within.
Item 16.
Item 16 is related to that appointment of the notification of the railway link project land outside from Sambalpur to Talcher, where my lord was concerned. A batch of case has been filed, out of which your lordship directed for the
All right, put up this matter before some of the bench, each one of us. look this is-
five matter.
Item 21.
Just one by one. 16, Aguda,
21, man.
22, my lord.
just 21.
Yes, man.
Sure. Sixteen, 21.
Yes.
22.
Yes,
23.
22.
22.
These three matters.
23 also. 23 also.
23 also, Sonaji.
These matters are never ending.
That already that has been listed before the honorable.
Sohola,
That is the key.
That will dispose it on.
They should get something.
Yes, yes, that will dispose it.
Yeah.
Item 17.
Already appealed and counsel filed on 10th/9 and copy already served to the appeal and counsel copy also served on 10th/9.
No, just a minute. This, in this matter, notice has been issued or you have?
He has handed over the copy. I have an advance, sir. But no notice has not.
Fresh admission.
Yes, sir.
Let it be then regularized that this thing, if you have already filed the counter affidavit, then it is to be hard on merit, then what is there? This,
And in the prayer question, he has made a wrong way number. I have
what
mentioned.
what
in
is the
my-
wrong?
That is way number he has mentioned in prayer question.
854.
Man, that was 856. Way number 856 by
कहीं से
two-
order ta kahin?
he has not filed the way copy and all the documents.
कोई order ta लिखा ही है, annexure 5 रे लिखा ही है। way number 8,
856.
हाँ, ସେଇଟା ହଉଛି 46 ରେ ଲେଖା ହେଇଛି, ଏମେ ଟା ଯୋଉ dismiss ହେଇଛି।
MA
ଲେଖା ହେଇଛି
number,
856.
just a minute, MA number ହଉଛି 333 of 2024.
Arising out of way number 856 by 2016.
ଏଇଟା ଭୁଲ ଲେଖିଛନ୍ତି ଆପଣ।
prayer ରେ ଲେଖା ହେଇଛି 800।
You have remanded.
ଲେଖନ୍ତୁ, the learning counsel for the opposite party.
2 and 3.
I am for the one.
किया counter affidavit किए file
I am on the Kendriya Vidyalaya Sangathan 2 and 3 I have filed.
Land counsel for the opposite party number 2 and 3 submitted that counter affidavit has already been filed on kebe filed
10 no and
10
copy handed over.
10/9/2024.
Plus with me.
Let the scanning be noted. Copy of the counter affidavit has also been served on the land counsel for the petitioner. Counsel is present for ଆପଣଙ୍କର ଏଇଟାର central government
Yes, man. See, they can act.
on behalf of the opposite party number 1. The learned counsel for the petitioner submitted that the impugned order is dated 1/10/2024, passed in MA number 333 of 2024, as well as MA number 359 of 2018. The time in,
That time earlier disposed of that time.
Who
Well, is dismissed for a default, then another dismissed for a default.
ବର୍ତ୍ତମାନ ଆପଣ କୋଉ order ଟାକୁ challenge କରୁଛନ୍ତି, କୋଉ MA ର order ଟାକୁ? 333. अच्छा, MA triple three of 2024, passed in OA number 856 of 2016. However, inadvertently, the OA number has been wrongly reflected in the prayer portion na body re bhi
Prayer portion.
body re theek achi.
Body re synopsis re ठीक है
In the prayer portion,
but in body
and
you have
he intends to file an interim.
in body I have not said.
ମୁଁ ଜାଣିନି ମୁଁ ଖାଲି ପଚାରିଲାଠୁ ଆମେ କହିଦେଲୁ ପ୍ରେୟାର ପୋର୍ସନ ଯଦି ବଡିରେ ଥିବ ତାହେଲେ ଏଇ ନମ୍ବର ଗୁଡା ଚେଞ୍ଜ
I will check.
ଲେଖିବେ କହିବେ ବଡି ତାହେଲେ ଲେଖିବେ ନହେଲେ
Synopsis is
and
correct.
he intends to file an interim application for amendment of the prayer version. है ना? Put up this matter such and such date, interim application if any be filed in the meantime, serving copy and so on such and such date for consideration of the interim application filed if any. है ना? For the date. Yes.
Item 18.
You,
The order under Annex 1 is 20.
counter affidavit ଆସିଗଲାଣି that's standing home. Next.
Here I'm challenging the order under Annex 1 as per the Central Administrative Tribunal. But whereby
Speak little louder.
where I'm assailing the order under Annex 1 the Central Administrative Tribunal Court of Malad, whereby direction has been issued to re-exercise the promotion to the post of private secretary from 1998 till date. This, to redraw that exercise, what has happened?
You are the petitioner.
But I was
You are the
opposite-
applicant before so and so.
opposite party.
Opposite party. Have you filed the original application?
Yes, ma'am.
So Subhash Chandra Parida is the applicant.
Yes, ma'am.
And the nature of relief which was sought for by him, that is dated, paragraph 8. He wants to pass the order dated 6/11/2018. And further said that he is entitled to get promotion to the post of private secretary with effect from such and such as proposed by this one soon. Or in the alternative, he please to direct the so also to consider the promotion so also to the post of private secretary. Okay.
And the third prayer is also important, madam. He wants setting aside of the promotion to of respondent 4 to 14, which was effected in 1997. So he also wants for setting aside of that. This OA was filed in 2017.
So what order was
And
passed?
the direction has been passed, my lord, page 39 is the operative portion.
But all
Para
those,
six.
Page 39.
all those persons have been arrayed as opposite parties.
yes,
All that they have. So they have been arrayed and I think they have entered appearance in the.
No, my lord, they have not entered.
At the stage of admission, it was dismissed.
No, no, my lord, they have, in fact, notices were issued, they have not appeared.
Well, that's all right.
Yes,
That is for them.
Then read page 33, para 5. Read it, we get a clear picture.
Para 5, my lord, may I please?
Admittedly.
Admittedly, rules 1988 that the recruitment, the promotion rule, my lord, is stenographer.
Read
rules-
little louder.
Admittedly, rules 1998 came into effect from 2/1/1999. The applicant was promoted to the post of PA as per rules 1999 on 19/9/2000. The date of such promotion was antedated to 14/7/1997. The draft seniority in the cadre of PA was published on 2/6/2005, wherein the name of the applicant was shown above the names of private respondent number 4 to 14. An agenda was prepared by the respondent number 1 on 9/6/2015, stating therein that the promotion of the private respondents 4 to 14 to the post of PS with effect from 14/7/1997 was not in order. In the light of the said agenda, the applicant submitted his representation on 23/6/2015. On 8/3/2017, draft seniority list of PS was published. Applicant submitted representation on 17/3/2017, praying for his promotion to the PS at par with his juniors, and he was promoted to the post of PS on 3/7/2017. On 14/7/2017, applicant submitted representation for his promotion to the post of PS when his juniors were promoted. On 9/11/2017, final seniority list of PS was published. Applicant submitted representation on 16/11/2017. The representation of the applicant was rejected on 6/11/2018. In the rejection, the respondents did not dispute the fact that the applicant is senior to the respondent number 4 to 14. They did not also dispute the fact that the promotions granted to respondent number 4 to 14 earlier to the post of PS was erroneous. It has been stated that the private respondent number 4 to 14 were granted promotion to the post of PAPS in compliance of the order of different benches of the tribunal even prior to 1998 rules came into existence. However, they have rejected the representation of the applicant on the ground that the so-called erroneous promotion to the post of PS was made about 9 years before, that is in the year 2008. And if the applicant would have any grievance, he should have raised the same at the time when the DPC for the said promotion was held in observing agenda.
তারপরে পড়ে শুনবো from to paragraph number 6.
Yes. The contention of the applicant is that he is entitled to get promotion to the post of private secretary as were given to P.S. Joyasri and S. Sitharaman is not acceptable since at that relevant time they were given promotion in 1997 when the posts as well as seniority were being maintained at regional level. Since the vacancy to the post of private secretaries were available in Karnataka region in case of P.S. Jayasri and in Chennai region in case of P.S. Sitharaman, they were given promotion to the post of private secretary in the year 1997. It is also seen that the applicant was not senior as per the regional seniority. Further, there was only one post of private secretary available in the Odisha region when the applicant was found eligible for such promotion, but another employee of Odisha region who was senior to the applicant was given promotion. Therefore, the claim of the applicant for granting him promotion during that period is not tenable. However, we are not able to accept the contention of the respondents that the applicant could only get promoted to the post of private secretary in the year 2017 after the retirement of incumbent private secretary, since only one post of private secretary was available in the Odisha region. After promotion of all India seniority, formation of all India seniority in place of seniority of regional basis, the promotions ought to have been made based on the all India seniority list after considering the suitability of the employees concerned as per rules. Hence, the case of the applicant for promotion to private secretary ought to have been considered based on the all India seniority list and certainly not on regional basis. Thus, the authentication of the manner of promotion effected would amount to violation of rules and law. Accordingly, we direct the respondents to re-exercise the promotion to the post of PS that was effected on regional basis in place of all India basis within a period of 180 days from the date of receipt of this copy of this order. May I just one more paragraph. What was our contention before the tribunal? Kindly see page 31, paragraph 3.2. That was our contention, madam. May I please? In terms of the recruitment rules 1998, actions were taken for effecting promotion against seniority quota and examination quota for the post of stenographers PS, but for the reasons of judicial intervention in the cases filed, the stenographers praying therein that the pre-existing vacancies should be filled in accordance with the pre-amended rules. Finalization of seniority list for effecting promotion could not be carried out. Now, kindly see paragraph 3.3, it's more important. However, in terms of judicial pronouncements, the vacancies available prior to the amended rules were filled up on promotion region-wise seniority basis. It is stated that since seniority, promotion, etc. were being effected region-wise prior to amended rules, and the persons promoted earlier based on the vacancies on the concerned region, even though junior to the applicant cannot claim the benefit on the ground of an employee being junior promoted earlier to him in other region. The applicant was correctly assigned the position as PA in the region-wise seniority list, but due to dearth of the post of PS, he could not be promoted. No junior to him was promoted based on the seniority list maintained regional. After the rules came into force,
97 rule.
98 rules.
98 rule.
98 rules. Various persons have approached to different benches of the CAT, and details of those cases have also been given. The orders were passed that the on-field seats as on the date of coming into force of the rules, those have to be filled up region-wise basis. Region-wise basis, not on all India basis.
Prior to
those vacancies.
After amendment, all India basis.
Yes, madam. So accordingly, those appointments have been made after coming into force of the 1998 rules on region-wise basis, though they were junior to the applicant. Those contentions were not taken considered while passing
but
the
what the tribunal only says, accordingly, we direct the respondent to re-exercise the promotion
from 1998. All these exercises
that
now
was affected regional basis.
Yes, madam.
So those,
And
now the orders passed by other benches, those will stare at us.
no, it doesn't say that the promotions which were given prior to 98, that also you remove. Doesn't say that.
No, promotions given up to 98 based on the vacancies as on the 98 pursuant to directions of various benches.
So you have to just pass an order. What is there? He has not stated, the Learned Tribunal has
Doesn't
not
say anything.
stated that you are to give the, just stated that you have to consider the promotion.
Yes, my lord.
So to re-exercise the promotion to the post option that was effected on so and so.
Now, my lord,
So you give the reason and dispose of
no,
that.
kindly see. The applicant has now retired since 2019. Now the tribunal is directed to re-exercise to the promotion since 1998 till 2025. My lord, if the applicant is entitled to, he has been, my lord, he is superannuated, he can be, some financial considerations can be given. Now we will be facing with the orders passed by various
Financial
benches.
implication केमती हबो आपण जदि ताकू न होल्ड करिवे that he was entitled to for such a so and so, how can you give that financial benefit? So that is the reason why ultimately now nothing will happen, he cannot get it, but the so far as this financial aspect
No,
is concerned.
Tribunal have said that he has not accepted the argument of the petition respondent. In the same paragraph, argument of the respondent has been rejected.
Of the applicant, my lord.
Applicant is
Original
rejected.
applicant, that was rejected vis-a-vis only 2 persons. Because they were appointed prior to 98.
Yes.
But after 98, my lord, those appointments which is challenging of respondent number 4 to 14, those appointments, my lord, were for vacancies as on the date of coming into force of the 98 rules. Those the tribunals have said, the various benches have said, no, though you are appointing them post 1998 after the coming into force of the new rules, which ought to have been an all India region basis, but since those vacancies were as on the date of coming into force of the 98 rules, you give them promotions on the basis of region wide. And in Odisha region, there was only one post of PS.
That
In 2017 only another post was created and he was given promotion. That letter is also there. In 2017,
all the 14 people were appointed, 4 to 14 were appointed after 98, but towards the vacancy prior to 98.
Exactly.
That's what you are saying.
Yes.
Prior to 98.
Yes.
The vacancy which has occurred prior to 98 has to govern the
Region-wise.
regional basis
Exactly.
principle, not the all basis.
That was not considered as passing in equal direction, my lord.
But it doesn't say anything in that.
Now,
order.
last 25 years, the exercise.
But where is that order?
There is nothing, just
There's nothing.
Re-exercise the promotion. So, not exactly stated the date, but if it has to be read in totality.
You pass that order saying that this is the position.
just you have to pass it.
Why
Nothing
have
has
you
been given.
The order is read in its entirety. It says,
No.
so after coming into force of the 98 rules, you redraw this exercise.
Where does it say that?
Nothing.
On the last line doesn't specify any dates, but in
Why are you inviting problem for yourself?
Just you are speculating something which is not there in the order.
Because
It is just
38, that's
you
half
have
a
to
sentence.
pass a reason order and give it that for this reason you are not entitled, whatever it may be. So unnecessarily.
The High Court, the tribunal only says that to work it out. That's all.
That's all.
To re-exercise the promotion to the priesthood that was effected on regional basis in place of all India basis.
Give the reason and dispose of that. So let the petitioners have challenged the order dated 15/1/2025 passed by the London Central Administrative Tribunal at a bench in OA number such and such. It appears that the opposite party number 1 filed the original application before the Land Central Administrative Tribunal seeking for following reliefs that is quoted in paragraph number 8. The opposite, the petitioners filed their counter and also filed the additional counter affidavit. The Learning Tribunal, after considering the pleadings of the respective parties, and hearing the land council for the both the parties. Pass the following order. Quote paragraph number 6 in its entirety. The main contention raised by the land council for the petitioners in challenging the impugned order is on the ground that the opposite party number 1 has slept over his rights for more than a decade, invoking relief only after the earlier judgments of different benches of the Central Administrative Tribunal, including the judgment dated 19/2003 of the Land and Cat Principal Bench, New Delhi, in case of Vinod Grover, had long been implemented. And thus, the opposite party is precluded from seeking reopening of the promotion granted a decade ago under judicial order. The further contention of the opposite party petitioners is that the opposite parties number 2 to 12, where the respondents number 4 to 14 before the Central Administrative Tribunal got the promotion in the year 2008 itself. And if the opposite party number 1 had any grievance against such promotion, he ought to have approached the tribunal in time. Having not done so, the he should not have been granted relief by the Learning Tribunal. Stop. After going through the impugned order, we find that though the notices were made sufficient on opposite parties number 2 to 12, but they didn't prefer to appear before the Learning Tribunal or to contest the case. The Learning Tribunal, in fact, has been pleased to hold that the contention of the opposite party that he is entitled to get promotion to the post of private secretary as were given to P.S. Jayasri and S. Sitha Rathan was not acceptable, since at the relevant time they were given promotion in 1997 when the post as well as seniority were being maintained at regional level. And therefore, the claim of the opposite party number 1 for granting such promotions during that period was held to be not tenable. The Learning Tribunal has stated in the impugned order that after the formation of All India Seniority in place of seniority of regional basis, the promotion ought to have been based on the All India Seniority list. After considering the suitability of the employees concerned as per rule, And therefore, the case of the opposite party number one for promotion to private secretary ought to have been considered based on All India seniority list and certainly not on a regional basis. Therefore, the Learned Tribunal has directed the petitioners to re-exercise the promotion to the post of PS that was effected regional basis in place of All India basis within a period of 180 days from the date of receipt of the copy of the order. Admittedly, the opposite party number one has retired, and in case, as per the order of the Learned Tribunal, he is given some relief, he will be entitled to only financial relief, and thereby it will not affect any of the opposite parties number 2 to 12 in any manner. In view of the analysis made in the impugned order, since the petitioners have been asked to re-exercise the promotion to the post of PS, and in that process, there is likelihood that the opposite party number one may get some financial benefit. We are not inclined to interfere with the impugned order. Accordingly, the writ petition being devoid of merit stands dismissed. Yes.
Okay.
Number 19.
Applicable. Last occasion, the Lordship on September 25 directed the opposite party to register their T to produce the order sheets and relevant records. They have not consider the dispose of the IA petitions. Petition.
The hearing runs from that a report be called for from the registered so and so relating to the status of in obedience to this so and so for a submission of the IA so and so is submitted from a transfer that of hearing the petitions. So same was posted for 3-9 and dismissed. This is and the delay petition so and so is dismissed. The main petition is also dismissed and so left on. Here use the communication made by the registrar of the Debts Recovery Tribunal Qatar dated 12th of September 2025, wherein it is mentioned as follows: postcode in obedience to the order dated to the tribunal. Therefore, the prayer which has been made by the petitioners in the writ petition has become infructuous since the interim application have already been disposed of. It is open to the petitioner to challenge such order in accordance with law before the appropriate authority. Yes, next.
Item number 20.
May I please read it?
Yes.
Might be.
So similar nature of case of delay of 33 years.
Yes, sir. This is Adivasi illiterate or lazy matter. Some payment was made, mother. Thereafter, they have not paid the payment, suffering pension.
Where is the order?
Order made of page 168.
Same family pension.
Same
That
family
case 29.
This is
Here 33 years.
Who एवढा सब रखी थे
आदिवासी लोक से जाते
आदिवासी এই ম্যাটারে গোটে অর্ডার আমি পাস করি তাকে দেখি ইস্যু
13
টু আইটেম নাম্বার 13
yes sir.
13 report
Item 13 रे, yes.
হ্যাঁ তারপর ইস্যু নোটিস করি টিকে চেঞ্জ হব কোন দেখি করবে সে বয়স তাদের ওটা 27 না কেতে বর্ষ ছিল yes next
Item number 24.
May I please alert? In this case, I am challenging the info order annex 6 manner, the order of the Central Administrative Tribunal, and directing the opposite party to give me a proper pay fixation order matter. Well, after retirement matter, after 4 years, they have not paid anything matter. After suddenly in 2023, they issue me PPO. PPO is based on pay fixation ordinance. In other case, means in my center,
order was passed in the MA miscellaneous application.
both they have had.
No,
And-
obviously this why the MA was filed.
MA was filed with a comparison minor because my center, I have returned after 2 years, another person is returned, he got the pay fixation order and I got a pay fixation order fake minor, but directly not them minor. I have applied to RTI. After 3 repeated application, they suddenly give me a pay fixation order, so-called pay fixation order, which is not genuine minor. There I have filed for comparison, the other person pay fixation order and mine to compare manner. Now that is the pay fixation order. This is my genuine. No signature, no seal. Pay fixation order usually they first send a copy to me, my lord. Copy of pay fixation sent to me, my lord, and copy to other section for
Now
implementation.
you have got the benefit that has been mentioned there. Financial benefits that you have got.
I have got.
Yeah.
But that is not properly calculated matter. That is why I have filed there for comparison. In this case, these are the, in my case, pay fixation of 4 to 5 steps they have omitted.
No,
Naturally,
then in that case, you are required to approach the authority first.
yes, I have approached.
To-
I have approached and
No.
I have filed there.
What is your prayer? Let us see that original application. What is your prayer? If some wrong calculation has been made according to you, then whether you approach the concerned authority and whether they have passed any adverse order against you which you challenged in the before
Yeah.
this central.
Only my representation is only give me pay fixation order.
That's all
But
right.
they didn't give me pay fixation. That's
Where is your OA application, madam? Where is your OA application and where is your miscellaneous application?
That copy I have not.
No, that is what we
I have
all
mentioned
the
that.
all these cases in which the order of the tribunal has been challenged here, we are insisting that you file the all the pleadings. And in this case, since you are challenging the order of the tribunal in OA as well as in that MA, you file the original application copy as well as the miscellaneous application.
MA, there was no order first, my lord. While I arguing away, MA has to be argued. I had both.
ଆପଣଙ୍କର ଗୋଟେ ମିସକେସ୍ ଉପରେ ଅର୍ଡର ହେଇଛି ସେ ମିସଲାନିୟସ୍ ଆପ୍ଲିକେସନ ନମ୍ବର ହଉଛି 683 of
That
2024.
that is not separately. Order was not separate, my lord. In this order only, they have mentioned, my lord, annex 6. I'm reading.
Why are you not filing the copy of the OA? We are asking you to file so that we can take up this matter.
Sorry, my lord, any day, my lord.
You tell me when you ask that when you file, if it is available, you can file by day
Yes,
after
sir.
tomorrow. So we can take up next week. What is that?
Next week. My
But in
office.
page 48 of the
My
brief,
office copy.
page 48, the Round
No,
Tribunal
certified,
observed that
you don't-
My copies.
that is
And
not-
next week or Friday, any day. You
Yes,
can find it with me, my lord.
Mr. Pari, let him file that, let her file that.
let the file because there is
original
a
application. Lekhantu. The writ petition has been filed by the petitioner, Miss Arnapurna Tripathi,
Anupama.
Anupama,
Yes.
sorry, Anupama Tripathi, challenging the order dated 15/7/2025, which has been passed by the Land and Central Administrative Tribunal in way number so bracket to miss case number 683 of 2024. In which both the original applications, also the miscellaneous applications were disposed of. Mr. Rakhi Sikdar, Land Counsel, appearing for the petitioner, seeks for an adjournment till next week to file the original application copies, so also the miscellaneous application, serving the same on the Land Council for the Union of India. Mr. Pari, Deputy Solicitor General, along with
Samantra, yes, we have sent it.
present, put up this matter. Monday we are placing, just file in the
Yes,
meeting.
Monday.
So on. 22nd of September it will come.
Yes, ma'am.
Next. Yes.
Yes. PK Padin, he is PK Padin, madam?
Yes,
Yes, madam, I'm sorry.
serve him or any the other name he has mentioned, any of them you can serve. Just get a receipt, that's all. Yes.
Yes, madam.
Number 25.
Madam, 25, madam, for challenging the order passed by the Central Administrative Tribunal. The copy of the order, my lords, Annex 5. Here, my lords, are the equal pay matters. The petitioner is a casual worker. What is the Annex 5? Page 87, my lords, order.
13 persons were the applicants before you.
My lord.
So,
Total were 157. Total employee earlier, my lords, challenge 57.
no, in the original application also 13 persons, right? And you have filed the original application from which we find that,
Hello, I am for the Union of India, my lord.
right, we know that, that the prayer was that you are to release the arrear wages. There were arrear wages from 1/1/2016 and to grant wages at the rate of 630 per day. That is one, so it prayer thila. Now, what the order was passed, what order was passed by the land?
The London Tribunal was directed
Yeah.
to pay the said amount, minimum scale of pay from February 2018 till today, the differential amount, my lords. Running page 103, my lords. Para,
Yes, we have seen.
my lords, 101, my lords, the para 39.
It has been held that gross injustice has been caused to the applicants in the decision-making process of the matter in stopping and deriving them 1/30th of the minimum scale of pay, so and so. Hence, they are entitled to 130. The 130 ta kud asla. 130 ta kud
My lord, the circular, my lord, first one.
circular thila.
Circular, my lords, page 87, my lords.
Page 87.
Page 87. 21/11/2017,
Just a
my
minute.
lords.
87. Acha.
In portions of my lords.
Important code lekha is 130th ta. Code file is.
My lords, the regular employee duly certified by the supervisory officer.
Page 87 ta hoji pra order ta.
Again, order lections. Again, so circular ta quoted question.
Acha. Pardon. In pursuance of.
In portions of DOPTMO number 49014/2/86. This is dated 7/6/1988. And EBCD is letters F number C 5.30014/41/2015. Dated 16/10/2015. It is hereby ordered that the payment of casual laborers whose nature of work is the same as that of regular employee duly certified by the supervisory officers, will be made at the rate of 1/30 of the minimum pay band, that is PB1 of rupees 5,200 within bracket 5,000 to 20,200 minutes. With the grade pay is 1,800. As per the recommendations of the with pay commission report notified by the government plus DA admissible from time to time on the said amount with effect from 1/7/2008.
This order is
This order
applicable-
is applicable to the daily wages laborers, public daily wages workers, public casual laborers of the income tax department within Odisha region. The above rate of wages is not applicable to any person, public daily wages laborers engaged through any service providers, public agency.
सर्विस प्रोवाइडर ପାଇଁ applicable ନୁହେଁ ଛାଡ଼
Right.
ବର୍ତ୍ତମାନ ଆପଣ ପଳେଇ ଆସନ୍ତୁ ଅପରେଟିଭ ପାର୍ଟ କୁ ଯୋଉଠୁ ଆପଣଙ୍କର ଅର୍ଡର ଟା କଲେ you come to paragraph number 13.
My lord. The learned counsel for the respondent placed the reliance of the decision of the Honorable Apex Court in the case of State of Haryana and others versus Charanjit Singh and others 2005-7 SEC 193 Supreme Court 193. The state that the applicant belonging to casual workers were not entitled to claim equal pay equal work. We have gone through the said decision and we find that the Honorable Apex Court had interfered with the order of the Honorable High Court. Since in the said case, there was no finding that the work discharged by the petitioners were similar to that of the irregular employees, whereas
This is important. पढ़ो
in the instant case, it is not in dispute that the casual workers after being engaged prior to 10/12/2018 are getting 1/30th of the minimum scale of pay. Stop. It is also not in dispute that the applicants were paid the 1/30th minimum pay scale till January 2018. Further, it is not in dispute that the applicant have been discharging the duty like that the regular Group D (MTS) employees of the department and the casual workers who were engaged prior to 12/10/2018 and are continuing till date. In view of the above, the decision relied by the respondents rather support the case of the applicants. It may also to recorded that the DOPT and order is very much clear, so that under what circumstances and situations the 1/30th minimum pay scale shall be allowed to casual employees. Hence, the corrigendum dated 14/12/2018 is opposed to the law and DOP and they thus cannot be made applicable to the case of the applicants. The case of the applicants also qualifies the conditions made by the DOPT in the aforesaid MOs. We also do not find any reasonable classification or criteria in depriving the applicants the 1/30th minimum scale of pay as because they have been engaged after 4/10/12/2018. Although it is not in dispute that discharging the same and similar duties like the casual employer after being engaged, continuing in engaging on payment of 1/3 of minimum pay scale. Hence, in corrigendum of facts, DOP and law, we find gross injustice was caused to the applicants in decision-making process of the matter in supporting and depriving them the 1/30 of the minimum scale of pay from February 2018. Hence, the applicants are entitled to minus 1/30 of the minimum pay scale level 1 within bracket 18,000 from February 2018 as was paid them up to January 2018. In view of the decisions made above, the respondents are hereby directed to calculate to.
So you are giving that benefit to them, but you
My lord,
suddenly
thereafter-
opt it from February 2018.
My lord, thereafter, my lords, the page 87, my lords, corrigendum second problem.
Corrigendum to lekha la clear.
Again, it is second, para 2 reminders.
Yeah.
Soon thereafter, the corrigendum was issued in 14/2/2018, stating their reminders. The second line of the second para of the office order dated 21/11/2017, my lord, the first, my lord, communicate in the memo number so and so dated 21/11/2017, containing the above rate of wages is not applicable to any person, public daily wages, laborers engaged through any service provider, public agency. In view of the board's letter dated so and so, may be read as the pay scale is not to be given to any persons, casual workers engaged directly on through any service provider or agency after 10th December 2008, my lords. The 13 workman is, my lords, after 10/12/2008. In view of the CBCS memo so and so dated 14/10/12/2008. The other contents of the said order will be.
So you have applied it retrospectively.
Yes.
So
Right.
suppose the money has already been paid to them, now you'll withdraw that amount from them.
Yes.
Clear thing? They have been paid wages right from 2008 by virtue of this 2017 also that order was passed. No, it is 2015. Enough? They the first one.
Okay.
So you have decided not to pay it to two types of persons.
Who is the appointment after 10/12/2008, my lord?
Right.
30%
If they are, the language is, if those persons are engaged to any service provider or agency.
Okay.
But if they are directly engaged by you, not through any so and so, like the petitioners,
Right.
like the opposite party in this case who are the applicants, then they are entitled to 1/30th of the minimum so on. So that benefit you have already given.
Right.
So
They wrongly payment, my lord, 1 years more wrongly payment.
but wrongly.
After the corrigendum, my lord, passed by the opposite person officers, the payment thereafter, my lords, modified the corrigendum, my lords, 2018. The same point, my lord, raised the casual workers or daily workers is not pay any regular.
What is the
basis.
financial implication?
ଜଣକୁ 600 ଟଙ୍କା ଲେଖା ପଡିବ
Per day.
per day ନୁହେଁ per month.
Per day, no, my lord.
ତାଙ୍କ ଅର୍ଡରଟା ଦେଖନ୍ତୁ 1/30th of the so and so ସେମାନେ ପାଉଛନ୍ତି ଯୋଉ 18,000 ଟଙ୍କା ତାର 1/30th 18,000 ଟଙ୍କାର 1/30th ହଉଛି 600 ଟଙ୍କା। 600 ଟଙ୍କା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଆସିକିନି ଫେବୃଆରୀ 2018 ରୁ ଯୋଉଟା ଦିଆ ହେଇଛି ତାଙ୍କୁ କେବେ ପର୍ଯ୍ୟନ୍ତ ଦେଇଛନ୍ତି?
January 2018.
Have you calculated what will be the financial implication?
No.
ସେ ଗରିବ ଲୋକଙ୍କୁ ଦିଆ ହେଇଛି ସେ ତାଙ୍କୁ ଅଲରେଡି ଖର୍ଚ୍ଚ କରି ସାରିବେନି ତାଙ୍କୁ ବର୍ତ୍ତମାନ
Time being, the central government notification per day.
that is the, you see, that is the Rafik Masiya case also like that. ଆପଣ
No question of
how can you, what persons they have already been paid?
wrong or right by the wrong interpretation of the provisions, it has been paid. How will you recover from them, the poor people?
This is not.
And you don't know also financial implication, how much. The small amount to forget it.
Because, my lord, our prayer is, my lord, there is a alternative remedies available. They workmen go to, my lord, central tribunal.
ଏଇମାନଙ୍କ ସାଙ୍ଗରେ ଇଏ କରିବେ ଫାଇଟ୍ କରିବେ କେସ୍ ଯୋଉମାନେ ଆପଣଙ୍କୁ 2005-6 ରୁ ସର୍ଭିସ 8ରୁ ସର୍ଭିସ ଦେଇକିନା ଆସିଛନ୍ତି 16 ବର୍ଷ ହେଲାଣି ଆପଣଙ୍କୁ ସର୍ଭିସ ଦେଇ ଆସୁଛନ୍ତି 600 ଟଙ୍କା ଆପଣ ପେମେଣ୍ଟ କରିଛନ୍ତି ତାଙ୍କୁ ଜଣକା ଲେଖା ଅଧିକା ଅଲରେଡି ତାଙ୍କୁ ସେମାନେ ଖର୍ଚ୍ଚ କରିସାରିଲେ ତାଙ୍କୁ ରିକଭରି କରିବେ ତାଙ୍କୁ ଦିସ୍ ଇଜ ଲେଖନ୍ତୁ WPC number so and so. This petition has been filed by the, sorry, please go. this,
My lord, this, your lordship, kindly see the order.
now we have seen the order. The writ petition has been
This
filed
judgment has been passed on basis of my lord's judgment.
by the, you are for?
My lord's order,
For
in view of the, my lord's
You
order.
are for, you are appealing for whom?
All the opposite party, I will appeal.
ठीक है. We are not interfering with it.
My lord.
This writ petition has been filed by the petitioners. Say order টা जो अच्छी दे दियो.
That has been quoted or.
Quoted.
Challenging the order dated 26/2/2025 of the Land and Central Administrative Tribunal, passed in way number so and so, in which the Land and Tribunal has been pleased to allow the original application and directed the petitioners and held that the opposite parties number 1 to 13 are entitled to 1/30th of the minimum scale of pay in level 1, rupees 18,000 from January 2018, as was paid to them up to January 2018. From February 2018, as was paid to them up to January 2018. And therefore, the petitioners were directed to calculate and pay the opposite parties number 1 to so and so, the differential area amount from February 2018 onwards, within a period of 60 days from the date of receipt of the order. It seems that the original application was filed by opposite party number 1 to so and so with the following reliefs. Inter alia, to अच्छा quote कर दिया उन्होंने पूरा. The petitioners, on being noticed, filed the counter affidavit and the opposite parties. And another affidavit was also filed on behalf of the petitioners by the Joint Commissioner of Income Tax, which is annexed to this writ petition as Annexure 4. The Land Tribunal after considering the ratio laid down in the case of so and so, has been pleased to hold as follows. Quote the entire paragraph number 13. The Land Counsel for the opposite parties has placed reliance in the case of Prasar Bharati Board so and so, which was decided in WPC number so and so. এটাকে reliance করছেন যে
No, no, but page, paragraph 12, they have quoted the order.
on which
This
paragraph?
12 of the order, improved order.
Just a minute. All right, on which the Learning Tribunal has also placed reliance. In passing the impugned order. The main contention of the Learning Council for the petitioners that the opposite parties number 1 to 13 were working as daily wages in different office and were not engaged to any regular recruitment process, and their nature of work was purely temporary and casual in nature, and therefore they are not entitled to get the relief as was given by the Learning Tribunal. However, we find that not only the tribunal considered the DOP and T number so and so as well as say you letter to order to lekha hoyche, you know, wherein it is specifically stated that the payment to casual laborers whose nature of work is same as that of regular employees duly certified by the supervisor officer will be made at the rate of 1/30th of the minimum pay band, that is PB-1 of rupees 5,200 bracket leke 5,200 to 20,200 with GP-1800 as per recommendations of the 6th Pay Commission notified by the government plus DA admissible from time to time on the said amount with effect from 1/7/2008. Specifically, it was mentioned therein that such order is not applicable to the daily wage laborers or the daily wage workers of the casual laborers of the income tax department within Orissa region. It was applicable like them. And this above rate was not applicable to any person public daily wage laborers engaged through any service provider public agency in view of the board's letter swans. Admittedly, the opposite parties number 1 to 13 were not engaged through any service provider public agency. Stop. We are of the view that since the opposite parties were engaged on casual basis directly by the petitioner on various dates after 1/12/2008, and they filed the original application to pass the corrigendum dated 14/2/2018, wherein it was held that not only the persons oblique daily wages laborers engaged to any service provider oblique agency in view, but also it would not be applicable to any persons oblique casual workers engaged directly, which was challenged before the Land Central Administrative Tribunal, and the Land Central Administrative Tribunal has considering this proposition of law as has been settled by the Honorable Supreme Court, to also by this court in the aforesaid Prasar Bharati Swanson, has passed the order. There is no infirmity or illegality in this sense, according to the improved order. The committee, according to the same stamps dismissed. Yes.
Item number 26, my lord, formatted to withdraw.
Item 20.
26, my lord.
File.
Yes, sir.
Wants to file a petition to withdraw the writ disposed of the
For the 26 for the opposite party.
Item 27, my lord.
26 is opposite party numbers wants to present. This
Item
item number 27 defects are not removed.
Permitted to withdraw.
Acha. Swanso Land Council appearing for the Swanso 6 permission to withdraw the writ petition accordingly disposed of as withdrawn. So 26 and 27 withdrawn for them.
Atmajit.
Atmajit Manmit Das, no? Okay. Appearing through virtual mode for the one.
Pardon. Pardon to mention only there was race admission.
There's admission.
Criminal offense.
Lordship, I may be pardoned to make a mention. Item number 14 from today's list, Your Lordship.
40?
1414, Your Lordship. It has been passed over, Your Lordship. I am seeking Your Lordship sincere
So
apology.
now we are taking up now the criminal match. 14 has been passed over.
Your Lordship.
Passed over, it will come day after tomorrow. What if I am mentioning? You have age to near yes.
Much obliged, Your Lordship.
Item number 28.
Yes, I am filling my law. For hearing my aspect.
Sorry?
If this matter, Your Lordship.
No, you filed a bail application. You know what is the report of the.
Yes, Your Lordship, that I have seen my lord.
Psychiatric
And his husband is already disowned her probably in that time of trial also.
No, the jail is not a place where this sort of treatment can be provided and he will be cured. He is suffering from psychiatric treatment. We cannot take every appeal for hearing every day. So it requires some time to adjudicate the matter. But when you have been entrusted to argue the matter and you see that the person is suffering, is in custody since how, when? You got trial court report. You see this 8/10/2007. Allah.
Right. I will file it.
No, you filed it.
No, the family members have disowned me. Disowned.
Yes,
Might be
Your Lordship,
disowned.
during that
That's
trial,
the nobody is taking.
husband is not supported. That is there.
No, we can pass the order that the state will taken care of. It's a different order, but you file and just write down this, file it so that it can be
I
taken
will
up.
file it tomorrow itself. Next week.
No, next week, no, day after tomorrow we are bringing it. File it.
I will file tomorrow. Oblige.
Mr. Tripathi, Land Counsel, submits that he intends to file an interim application for bail since the appellant, who is an old lady, her age in at the time of filing of the charge sheet in 2007 was 40. So now 18 years, so he must be 60 now.
60.
Who is now is about 60 years, is in judicial custody for about 18 years. Put up this matter day after tomorrow with the interim application, if any, filed by Mr. Tripathi. Yes.
Item 29.
Yes, item number
29.
Mr. Prem Kumar Mahanti is.
Instruction has come.
Prem Kumar Mahanti, I think he's
The instruction was sought for. Obtain instruction, the release prematurely, release or not.
That does not use weeks.
May 1st May 2025 order.
Let next week I will intimate the Prema's as well as the bring the report on the.
right on.
Have you written letter?
That what has not been done.
No, you call that, the superintendent, Rairanpur jail. ওরা নিজে না লাগলে হবে না। Call him.
Item 30.
Mirrored, release of images.
Full of loss. Premature release is disposal for them. Next,
Item 31.
these matters have been listed because we asked the DR to instruct the superintendent have also come that each file of the jail criminal appeal should be verified. And it is to be seen that whether they have been released on bail or not. The persons in the jail criminal appeals who have not been released on bail, those cases are to be listed before us. And accordingly, these cases have been listed. Now, this is a 2014 appeal, jail criminal appeal. Trial court record bhagan. Custody since 3/10/2012. So almost 13 years. And the counsel who was engaged is when he was engaged. He was engaged in 2014 and is not appearing.
Change.
Say panel is to non-appears for the so and so is engaged as the counsel. Hello? Intimation is item number 28 day after tomorrow. Hello? 29 to Dokaichi Rairanpur se jail superintendent produce karibe. Yes, next 30.
Item 32.
You are appearing?
No.
On behalf of Corona, that is intimate to adjournment. This year is not.
No question of giving adjournment.
Day after tomorrow, I will
See the final report. Final form. Final form shows custody since 2011. Place it day after tomorrow.
Day after tomorrow.
Yes.
Probably.
Item 33.
On behalf of CSL, I will take instruction in this regard.
Sorry?
I will take instruction in this regard. About
2011. 302 case. Yes, what is your instruction?
I will take instruction.
No question of instruction. We are changing the council. Council changed day after tomorrow. Yes. Next.
Item 34.
Yes, admit भी है। Admit ही देख लो। When order sheet is admitting. 02 life में problem है।
Number 7, appointed as a notice colleague.
Yes,
ऐसी भी नहीं होती। Admit ही चाहिए।
जी
14/7/14 admit.
हाँ ठीक है। Change the counsel. Day after tomorrow. Next.
Item 35.
So phone कर दिन जाने के उस counsel. Actually matter there.
The name of the council to be appointed should be reflecting.
हाँ.
Everywhere you write. Name of the council who is engaged recently shall be reflecting in the. That's very important.
And this name shall not be reflected.
हाँ, पूरा नाम करेंगे ना नाम.
ସେଇ instruction ନଥିଲା ବୋଲି ଫାଇଲ କରିବୁ।
Speak little louder.
नहीं प्री मैच्योर रिलीज है तो फाइल को देखे तारी पाए।
Double cut लेते
I have contacted
से केंद्रापड़ा जेल ले थिले केंद्रापड़ा कौन तू हाँ जी ये करिए अपीयर करिए हाँ से लोग को नहीं गिनी पाणु बेहरा
ना उधर आना दो
हाँ अब जी अच्छन से
दिन बाद है
पास ओवर कर चु इमीडिएटली कौन तो यस नेक्स्ट
Item 37.
नहीं कस्टडी दवा सुना मैं बार बार ठीक है 3 2012 nobody is there এটা কোড জেল দেখি বরবিল কোন তো জয়েন করিও 500 কোড বরবিল এটা হলা বরবিল আর ওটা হলা 36 টা কোড কেন্দ্রাপড়া আর ওটা প্রতিটা যে কইছিল হ্যাঁ কত নম্বর 29 টা কোড ঠিক আছে নেক্সট দেখুন
Item 38. No.
Pilot item 38 on behalf of Ms. Number that this matter was taken up 2 weeks after. Yesterday her sister had died, my lord. Therefore, on her behalf I mention.
how many years is in custody division no 2009 order sheet the coach in jail class
Is the report अच्छी की?
Producing custody ना trial court of bail मत दिया
38.
so
38
Miss Nanda, this younger sister has expired, she has requested.
No, it's all right. We are granting him bail. More than 15 years he is in custody, 302 case. देखिए कौन वाला judgment है देखिए. Bail application has been filed. जो ଝିଅ କରୀନାକୁ throttling କରି death ହେଇଥିଲା ବୋଲି allegation. Limit ତ ହେଇଯାଇଥିବ. Purpose of the appellant कौन ଆସିଲା?
18/2/2009 କଷ୍ଟଡି ଅଛି. ଆପ୍ଲିକେସନ ଅଫ ଏସଆଇଟି
15 ବର୍ଷ ବଡ଼ ବର୍ଷ ହେଇଗଲାଣି. 2009 ମାନେ 16 years. More than 16 years. 16 years, 6 months.
never release of the
No,
Record is
record not so. Hard Guardian Council, hard living. Is an application for bail. The petitioner is in judicial custody. Then it's
18/2/2009.
I should produce that account of 19 to 2009. He was never released on bail during trial, as it appears from the trial court record. Since he is in judicial custody for more than 16 years and 6 months, and there is no likelihood of the appeal being taken up for hearing near future, he is released on bail and stay realization of fine. Order copy be communicated to the jail superintendent by the Registrar General, Registrar Judicial, and also a free copy of the order be handed over to the Land Council for the stay relation of fine be allowed for the. Yes, next.
Item 39.
39.
apprehension report was called for. After release on bail, he did not surrender.
What is the report?
The report was called for.
We direct the issuance of the so-and-so and its production before the trial. You have not obtained any instruction?
No.
You actually submitted the written instruction, which is reflected in 2011-2023 order, that he has been granted interim bail for 2 months and he has not surrendered. So we directed for issuance of non-bailable warrant of arrest and production. So it is your duty now to execute the NBW and produce it before the trial court. You are unable to say whether the.
That's why I put some time, because whether he has apprehended or
Surrender apprehended or not.
NBW.
Put up this matter on 22nd of September 2025 as prayed for by the Land Council for the state to obtain instruction as per the order dated 2011-2023 as to whether, by virtue of the non-bailable warrant of arrest issued by this court, the appellant has been arrested and produced before the land trial court or not. 3 copies of the order be handed over to the land council from the state. Yes.
Item 40.
Appellant has been custody 12 years, 3 months. More than 12 years and 3 months. Prisoner's petition at 5C.
Conduct and jail conduct of criminal antecedent and custody.
More than 12 years.
Yes. Total conviction period has been 3847. 38% conviction under trial period of 599. Total has been 4446.
Eight for 7 মানে কেত দিন হলা?
Total ହେଲା 12 ବର୍ଷ 100 କେତେ ଦିନ? 12 ବର୍ଷ 12 years and
12 ବର୍ଷ ହେଇଯିବ। Found nothing adverse. ଯାଇଥିଲା କେବେ ବେଲ୍ ଫର୍ମ?
ନା ଯାଇନି। ନାଇଁ ଯାଇନି।
ଯାଇନି ଯାଇନି। Offense କଣ?
302.
How many murders have been?
1.
Axe blow was given on the neck.
Yes.
Finger blow. Yes. Assaulted the mother.
Conviction based on PW1.
Eyewitness is there.
PW1. But cross examination, he has said that before I arrived there, PW4 is present. But PWR4 came after the arrival of the
as for the order dated 3/9/2025, the Land Council for the state has produced the custody certificate which from the Superintendent District Jail, Keonjhar, which shows that the petitioner is in custody for more than 12 years. He has also obtained the instruction from IIC Pura Police Station, Keonjhar, to show that there is no criminal antecedent against the petitioner. Land Council for the petitioner submits that in the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that PW1 is an eyewitness to it. And the evidence indicates that the petitioner assaulted his mother by an axe on her neck. And the doctor PW8 has also noticed an incised wound on the neck and who find that the cause of death was due to hemorrhage and shock on account of injury to carotid and spinal column of the neck. Case 5 of the judgment reflect his cause of death. Considering the submission made by the Land Council for the respective parties, in view of the evidence available on record, are not inclining to release the petitioner on bail on merit, but keeping in view you let the case, in the period of detention, 3 months bail granted. Yes.
Item 41.
No. It's about say,
No, more than 9 years, my lord, is in custody since 2/7/2016.
That was your submission also. Each may have a custody. What are you dealing this matter?
Have you written the letter?
Yes, yes.
एक नंबर ऑर्डर पास होला और 2 सप्ताह पास करी गलानी कोई जेल से अछि you are keeping it to अछि No, what's no matter.
No, it's not.
No, 2025 no ଏବେ करता हूँ आगु रिजेक्ट ही नतला
No.
what is the case about?
It's based on circumstantial evidence. No evidences are there. This is the wife of the present appellant. And my lord, another person was in PW 16 man. He was the uncle of the appellant. The appellant was suspecting that there is a relation between her his wife and the uncle PW 16.
So what are the circumstances available on the
Logically, see page 19 of the judgment. The trial court has given the
19 paragraph 12
paragraph 12.
Schedule 19 the eyewitness as well as the injured.
eyewitness को मना करछन्ती
No, no.
Eyewitness injured or
Injured.
page 5 the internal judgment 63
The present petitioner had asserted the deceased past murder thereafter while he's inside the village murder. He
internal
asserted
page 5
the
of the judgment PW 19 chapter Kido is the eyewitness as well as the son of the injured
एबे का कोटा कहछन PW 9
19
19 accused gave a blow to his father by means of an axe and
That is
he snatched
related to
up
307.
That
is related to 307. That he has been convicted under section 302, 307, and 324.
Turn to 302
okay
No, that 307 didn't turn to 302. Mother died.
नहीं नहीं
Sorry, wife.
307 ହେଇଛି ତା ବାପା କୁ ଯୋଉ ଆକ୍ସ ବ୍ଲୋଟା ଦେଲା 302 ହଉଛି ସେ ଯାହା କହିବା କଥା ଯେ ୱାଇଫ ପାଇଁ ହେଇଛି
ସେ କହୁଛନ୍ତି
ତା ୱାଇଫ ନାଁ ହଉଛି
307
ଏଲିଜାବେଥ
302.
କିଡୋ that is mentioned in paragraph number 4 page 5 of the judgment
again
so whether on 2/7/16 early morning accused committed murder of his wife Elizabeth Kido paragraph 4
again
ସେଇଟା ହଉଛି 302 ଆଉ 307 ହଉଛି whether he assaulted his related uncle Noel Kido by means of an axe ସେଇ ଯୋଉ ତାର ଇଏଟା ହଉଛି ଆଇ ୱିଟନେସ୍ ଟା ହଉଛି ତାଙ୍କର 90
16 ବି ମନା କରିଛି again, he was not present there.
but the circumstances which you have pointed out has been jotted down in paragraph number 12 that you and your wife were staying in the same house.
Yes. Yes. Very often they used to quarrel.
Very often there was quarrel between them. You were assaulting. Then the disclosure made by the accused son regarding quarreling between his parents. And in the relevant night till next morning, the accused was the only person remained in the deceased. Soon after the assault, the accused went to the injured's house and also assaulted him by means of the same axe, causing injury to the back. deceased had external injury inside wound also the wife. Dead body court mila ghoru.
Dhorwal. He was present here.
There is nothing on record that any was had any enmity or anything. Injured so and so. ସେ 19 ବୟସ କେତେ ନହେଲେ ଯାଇ ସେ ପୁଅଟାକୁ ମାରିବ ନା evidence against the
People will see the statement in the children. They are stating that I am taking a lordship to
21 years.
opened of 3, 14 and 23 men. Some daughter. Nobody was there. PW3 is saying that I am reading out that particular. It is a fact that my father and mother were leading a peaceful life prior to the death of my mother.
3, 4,
3, 14 and 23 men.
14.
Yes. Please
All are children.
3 children. Both of them are leading a very happy conjugal life. Then Miller University can see
3,
14.
14, okay.
14, 23.
No, this 1423 turned hostile.
Yeah. 3.
बाकी ये क्यों सपोर्ट कला 3 टा.
Yeah.
But what about this 19 who deposed against you?
19 Miller, the son of the Noel Miller. 307 Miller, his uncle. He is statement. Reading the statement of PW 16 first year, the injury. I do not know the informant of this case, namely Vinod Singh, as the name suggested. I know the accused appearing in the screen video. I know the deceased wife of the accused, Elizabeth Kido. Last paragraph. The date of occurrence was 2/7/2016. Due to the assault by the accused, I fell down on the ground. My son rushed to the spot, caught hold of the axe of the accused while he was again assaulting me by the said axe and rescued me.
Who is the doctor?
Dr. Miller, PW 18.
15.
PM.
Yes, PM.
PW?
PW 18.
18.
PW 16 stated that his son was inside the house, he was never present there. But PW 18, the son stated,
Inside road agachi.
After inside is into 1 into 7.
Hard the land counsel for the petition, land counsel for the state. Land counsel for the petitioner. As the state has produced the custody certificate of the petitioner from Superintendent District Jail Sundargarh dated 9/9/2025, which indicates that the appellant is the petitioner is in judicial custody for 9 years, 9 months. The said report is taken on the phone. Land counsel for the petitioner argued that so far as the commission of murder of judgment of the deceased charge for
Elizabeth Kido.
Deceased the deceased wife Elizabeth Kido is concerned. It is based on circumstantial evidence. And the matter is not likely to be taken up for early hearing in the near future. And therefore, the bail application of the petitioner may be favorably considered. Land counsel for the state submitted that petitioner also assaulted PW Kakmarla 16, PW 16, Noel Kido by means of an act for which he also faced charge under section 307 of the Indian Penal Code, and the Land Trial Court also held him guilty for such offences. And the evidence of the doctor who conducted postmortem examination, that is PW 18, as well as the doctor who medically examined PW 15, that is PW 15, are also very relevant on this aspect, considering the submission made by the learned counsel for the respective parties, nature of evidence available on record, and the postmortem report findings, while not inclining to release the petition on bail on merit, but keeping in the period of detention in judicial custody. As per the custody certificate produced, we are inclined to release him on interim bail for a period of 3 months. Sterilization of fine. Yes.
Item 42.
I was engaged in amicus curiae for reform.
Okay. Since Mr. Durgadutta Mahapatra and his associates have filed wakalatnama for the appellant, the name of Mr. S.N. Mishra shall not be reflected in the cause list henceforth. Yes, what about the bail?
Convicted under POSCO. POSCO conviction.
Notice जाएनी?
No.
IN number 1, so it is an application for bail. Since one of the offense under which the petitioner has been found guilty is under section 6 of the POSCO Act. Let the learned counsel for the state serve a copy of the notice on the informant, and बाकी वैसे जो बड़ा बड़ा वैसे से informant को जानेगा वकालतनामा sponsor. This matter is to be placed after ensuing puja holidays for consideration of the bail application. Yes, next.
Item 43.
Since about 6 years now, the entire case is based on circumstantial evidence.
One eyewitness, PW 20.
Eyewitness achandi?
PW 20.
Not it's the observation of the Lord High Court that the entire case is based on circumstantial.
Place the deposition of the PW 20.
Before that, I want to place the FIR.
No, let us be clear whether it's a case based on direct evidence or you come to PW 20. Occurrence took place once, so again says occurrence to. Otherwise in the process.
2 years.
Pardon.
The occurrence took place 1 month back. Again says the occurrence took place 1 year back. One day after, at about 4 p.m. Near the house of the accused Ankur Bidu, my mother was in brother's house. Then the accused came there and called my mother Birang.
His mother is the
deceased.
Yeah.
And gave her handia on the village mandap. The accused has also taken handia receipt. Then the accused Ankura Birua brought tangia from his house and then dealt blow by that tangia to the neck of my mother, causing serious cut and bleeding injury. Then my mother fell down and died. Then the accused threatened saying to kill by shooting arrow. Then I called the villager to the spot. So should I kindly see next page? Third line from the bottom, Your Lordship. In the cross examination, so he says, again says, myself and my brother saw the accused Ankura Birua dealt a blow by Tangia to my mother.
How do you say that it's a case based on circumstantial
My
evidence?
lord, the PW 17 and 20, the son of the PW 17 came and stated before.
17 is a post occurrence of witness.
My lord, I the son of the PW 17. They both, the PW 17 and PW 20 were at the hospital. They were at the hut, village hut, about 10 kilometers away from the occurrence. And after returning home, the son of the PW 17 stated that his grandmother and the present appellant taking handia and sitting in the occurrence place. Thereafter, they both went in a cycle to the spot, and before that, they arriving at the spot, there was also police personnel at that place.
That is a question of appreciation, but the evidence indicates that he is an eyewitness to this.
The 53 page FIR.
This
From the beginning, he stated that I heard the appellant had murdered my mother. Thereafter, Kangoli, Pachari Bujili.
have you brought out anything in the cross examination? So that he is a post occurrence.
I'm placing the PW 20, the
We have seen that. Again, paragraph number 3 रे सेटा से point out करते again says myself and my brother saw the accused so and so dealt blow by Tangia to my mother.
But PW 17 totally
17 कौन यार और cross examination में कौन बाहर करते
I am placing the 3, para 3. I know Ramesh Marandi of Varusai, whose house is adjacent to the house of the accused Ankura Birua. My mother was killed near the house of the accused Ankura Birua.
And who is the evidence of the doctor?
Doctor stated that the
Seven.
weapon of offense.
CW?
7.
7. एरा तो फिर DW लिखा है इधर PW करेगा मम्मा इच्छा से कर दूंगा
Multiple injuries.
There is some unfaithful that the entire case is based on circumstances.
Suspecting witchcraft, he has killed the deceased.
eyewitness टा किए होला सेटा
20. 20.
But he is seen only giving one blow.
He has seen assaulting, the accused assaulting the deceased.
4 injuries are found.
4 injuries.
टांगिया ब्लो भी एक है ये ही और टांगिया टा नेक रही थी but the doctor found lacerated wound. What injury की incised wound नहीं
Left ear पकड़े.
Abrasion. Fracture ହେଇଛି parietal and occipital regions also. So what we call for in this case?
What is the custody period?
About 6 years, just 10 to 12 days to be completed in 6 years.
After puja holidays तो खाली स्टे रियलाइजेशन ऑफ फाइंड आउट कर दिया तो अलाउ कर दिया नेक्स्ट
Item 44.
44 deposition copies are not there.
जेल क्रिमिनल अपील आपण नहीं जान पेन ड्राइव
I've already.
एटारे हां ट्रायल कोर्ट तो अछि हो
This case
Land counsel for the state submit that she is not having the deposition copies with her and she may be permitted to take the deposition copies since soft copy of the trial court record is available in our pen drive, registry shall supply the same to the land council for the state. Out of this matter next week for them. 22 তারিখ 2025 yes next
অনলাইন আসেনি তখন কি সুপারিনটেন্ডেন্ট আসলে
Paper has not been prepared in this. PCR is in. Item 29, the jailer from the Rairanpur project.
রাইরংপুর
Yes. Item 29.
অর্জুন কুমার পন্না
29
আইটেম
29.
Raju alias Raju Mohanto. লোক আছে কি টাকা টাকা আইটেম
Item number 29.
yes রায়রংপুর জেলে কি ଅଛନ୍ତି
ସାର୍ ନମସ୍କାର ସାର୍ ଅଞ୍ଜନ କୁମାର ପଣ୍ଡା ସାର୍
ସେ ଆପଣଙ୍କ ଜେଲରେ ଜଣେ ବ୍ରଜ ଓରଫ ରାଜୁ ମହନ୍ତ ଯିଏକି এই ক্রিমিনাল আপিল দাখল করেছি ଆଉ ସେ এই কেসটা হଉଛି 2008 ମସିହାର କେସ୍ ଯେମିତି କିଏ ଲୋକ ଅଛନ୍ତି ନା
ସାର୍ 24/1/2013 ସେ ବାରିପଦା ସର୍କଲ ଜେଲକୁ ଟ୍ରାନ୍ସଫର ହେଇଛନ୍ତି ସେ ସେଠି ଫର୍ଦର କନଫାଇନମେଣ୍ଟ ପାଇଁ ସାର୍ ସେ ବର୍ତ୍ତମାନ ନାହାନ୍ତି ସାର୍
ଆଚ୍ଛା ଲେଖନ୍ତୁ through the order dated 1/5/2025, the London Council for the State was asked to obtain certain instruction, but it has not been obtained. After perusing the wakalatnama signed by the appellant, we instructed the London Council for the State for making appearance of the jail superintendent of Rairangpur sub-jail, and accordingly he appeared Kurchandi.
Ranjan Kumar Panda.
Mr. Ranjan Kumar Anjan Kumar Panda, what is
Superintendent.
Superintendent. That is a sub-jail, Mr.
ସାର୍ 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 ସବଜେଲ ସାର୍
Unmute କରନ୍ତୁ.
Subjail.
ନାଇଁ unmute ଶୁଭୁନି.
Unmute ହେଇନି.
ସାର୍
ଆପଣଙ୍କ subjail.
ସାର୍ ସବଜେଲ ରାଇରଙ୍ଗପୁର ସାର୍
Acha, submits that the appellant was in Rairangpur sub-jail till କେବେ ପର୍ଯ୍ୟନ୍ତ ଥିଲା?
ସାର୍ 24/1/2013 ରେ ସାର୍ ସିଫ୍ଟିଂ ହେଇଛି ବାରିପଦାକୁ
But on 24/1/2013 he was shifted to कोडी shifted hala
ସର୍କଲ ଜେଲ ବାରିପଦା ସାର୍
Circle Jail Baripada. Will matter be placed day after tomorrow in order to enable the Land Council for the state to obtain the well-being of the appellant. Hola, that should be assumed. The personal appearance of so-and-so is dispensed with. Hola, all right. It actually will day after tomorrow.
Is another officer is there?
So you're locked on. Barbil look white on
Item
or 37. 47 dollars.
37.
34 with item 34.
Sir, kindly unmute. Item 37.
Warbil jail lu kiye achanti?
ଆପଣ ବରବିଟ ଜେଲର ଆପଣଙ୍କ ନାଁ କଣ? ସରି କେନ୍ଦ୍ରାପଡ଼ା ବରବିଲ
ନାଇଁ ନାଇଁ କେନ୍ଦ୍ରାପଡ଼ା
same ନା?
କେନ୍ଦ୍ରାପଡ଼ା ହଉଛି item number
Item
36.
36.
Item 36.
Kendrapada, it is 36. Just. It also is Kendrapada kung kayo ko. Huh?
36.
36. Panu Behra. The signage is true. Silver circle yellow signage. Case Uchi conviction Kendrapada. But he is not in Kendrapada. ये लोग नथियो ए पाणु बेहरा की अछंती आपन को जेल ले
सर से 31/3/14 रे एडमिशन हेतिला 6/4/14 रे सर्कल जेल कटक को सर ट्रांसफर हे
ठीक है रोन तो बिंबा बेहरा को बात
बिंबा बेहरा सेकंड अपल
हां
सेकंड अपल
नहीं जेल क्रिमिनल अपील टा
ଦିନ ଅଛନ୍ତି
एसटी केस
अब 2014
arising out of one ST case number 139/2010 and another
just पाणु बेहरा और किए दिजन अछंती हां दिजन दस्तखत करते पाणु बेहरा बिंबा बेहरा पाणु बेहरा आपनकर केन्द्रापड़ा जेल ले थिला
सर
केबे गला 14 को
सर 6/4/14 रे गला
10/4/2014 आ गोटे ना आसुची बिंबा बेहरा बेली
सर बिंबा बेहरा सोना पाणु बेहरा
हां कौन हला
सी भी सर सही 31 दिन में जॉइन करता 31/14 रे ट्रांसफर दी सर्कल सर 6/4/14
सही ठीक 14 को
सर
दी जन जाक 10/4/2014 रे ट्रांसफर होइछंती
6/4/14 सर
6/4 ओके तो एटा नहीं आसंदु तांकोटू ये करिकिनी आमे सी पर दिन को रखुची 14 जेलु निमसो लिखि दियंतु when the matter was taken up Mr. Pulakis Mahanti London Council was engaged in amicus curiae, submits that he is not aware about the well-being of the appellants, for which he is unable to file an application for bail. Since the trial court judgment indicated that both the appellants, namely Tanu Behera and Bimba Behera, faced trial in the court of London Session Judge Kendrapada we instructed the Land and State Council to ensure the appearance of both the appellants to ensure the appearance of the concerned jail superintendent to ascertain the well-being of both the appellants. Mr. on Nata Pele.
ଆପଣଙ୍କ ନାଁ କଣ?
ସୁକାନ୍ତ କୁମାର ରାଉତ ସାର୍।
ସୁଶାନ୍ତ କୁମାର ରାଉତ।
Sushant Kumar Rao.
Sushant Kumar Raut, you are the
Superintendent sir. Kendrapada.
superintendent. Superintendent Kendrapada Jail submits that the appellants are the father and son, and they were in Kendrapada Jail. Huh?
Husband and wife.
Husband.
Oh, husband
Bimba the wife of
husband and wife, and they were in Kendrapada Jail, but they were shifted to Chaudhar Circle Jail Chaudhar on 6/4/2014 कहले परा
Sir, 6/4/14.
6/4/2014. Stop. The Land and Council for the state submits that the matter may be taken up day after tomorrow in order to ascertain the well-being of both the appellants. Put up this matter on 17th of September 2025. The personal appearance of the superintendent of Samso Jail is dispensed with. A free copy of the order be there. It has day after tomorrow. ଆଉ ଗୋଟେ ବରବିଲ ବାଲା ଆସିଲେ
connect हो
ହଁ
connect होने लेट हो
କନେକ୍ଟ ହଉନି ଏଇଟା ପରେ ହେଲା ସେଟା କାଟି ଦିଅନ୍ତୁ କେନ୍ଦ୍ରାପଡ଼ାଟା କାଟି ଦିଅନ୍ତୁ ବରବିଲଟାକୁ ଦେଖନ୍ତୁ ହଉନି ତା କହୁନାହାନ୍ତି ଆଉ ଥରେ ଲଗେଇବ ପ୍ରେସ୍ ଇଏ କରିକି
ଜଏନ୍ କରିଛନ୍ତି ଦେଖିଲି ଏଇନା ଜଏନ୍ କରିଛନ୍ତି देखो डेटा स्केल हेडफोन संख्या
ଆଉ ଥରେ କୁହନ୍ତୁ ତାକୁ ଜଏନ୍ କରିବ ହଁ ନେକ୍ସଟ ଡାକନ୍ତୁ
Item 45.
Yes, 45.
Case. Mr. was in custody since 17/9/2020. About 5 years.
ଏପଟକୁ କପି ନେଇଗଲେ ତ
Yes.
କଣ ହେଇଛି କୁହନ୍ତୁ ଆପଣଙ୍କର
The entire case is based on circumstantial, there is no ice name.
you have committed allegation that you have committed murder of your father.
No.
How?
The friend. One of the friend of the,
Acha.
they are both and
So what are the circumstantial evidence?
evidence that last will theory and a declaration, dying declaration and a
Dying declaration ଅଛି okay କାହା ପାଖରେ dying declaration
9 and 3
TDO ଅଛି 9 and
3
3
389.
अच्छा 3 8 9 ଗୋଟେ dying declaration को ଆସନ୍ତୁ ये ପଢନ୍ତୁ ତିନିଟା ପଢନ୍ତୁ
Is 80.
ପଢନ୍ତୁ ଆପଣ ପଢନ୍ତୁ ଜଗଦୀଶ କଣ ପାନିକା
This Panika.
ପାରା 2 କୁ ପଳେଇ ଆସନ୍ତୁ
Para 2 person. Para 2. The occurrence took 1 year back. I was ward member of ward number 4 of village Hina. On the day of occurrence, some villagers called on me to the spot and found Katin lying there.
Ketri ହେଲା deceased ଆଚ୍ଛା
Yes.
ହଁ
In a dying condition. There was a bleeding injury in his head, face and hand. I asked Khetri as to who inflicted injury on him, and he disclosed before me that the accused Bangula, present appellant, inflicted on him. Thereafter, by means of an
ambulance, F3 was shifted to hospital. CSC Cantonment. He was referred to PHS Balangir and succumbed to injury. In cross-examination, he has disclosed that the injured was in talking condition. 8 to 9% comprising the family of the deceased. The family members of the deceased arrived at the spot after half an hour of our arrival. Police had also arrived there at the spot prior to my arrival. The police was present at the spot when the deceased gave the statement to me, but the police has stated that no dying declaration has been recorded.
It has also stated that on being asked, they disclosed that he was assaulted by means of an iron pipe. 9 also stated that I found my father lying with bleeding injury. There was deep injury on the head, left side face and assault mark. I asked my father and my father disclosed that accused Bangula assaulted him by means of iron rod. So, who is the doctor who conducted PM?
Doctor is
39.
39. $149.
Guda injury, lacerated wound, cut wound.
Your custody period?
The weapon has not been.
Your custody period of custody?
About 5 years. 5 years. 2 days, sir.
After Puja. Yes, next.
Item 46.
46, Mr.
Sir, call for a conduct.
ଯାଇଥିଲା କି interim bail?
Yes.
କେବେ ଯାଇଥିଲା?
6/5/2024.
କେତେ ମାସ ପାଇଁ?
4 months.
No involvement in crime. No enmity. କେତେ ବର୍ଷ ରହିଲା ପରେ ଆପଣ ଯାଇଥିଲେ ବେଲରେ?
Around 6 years. 6 ବର୍ଷ ହେଇଛି। 6 ବର୍ଷ ପୂରି ଯାଇଛି 4 ମାସଟା କାଟିଦେଲେ 6 ମାସ।
6 years.
Yes, sir.
Is of 2019.
हाँ?
Incident is of 2019.
नहीं, final form definitely he was taken into custody on
15/9.
15/9.
Yes, sir.
15 na 19.
15/8
Sorry, 15/8.
15/8/19
Yes, sir.
15/8/19 ମାନେ ତ ଆପଣ ଇଏ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ ନଥିଲେ କି?
No.
Court record of order sheet at the accused produced in custody, produced in custody, produced in custody. ନାଇଁ ସେ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ ନଥିଲା। So ଇଏ ହେଲେ 6 years ହେଇଗଲାଣି।
Around 6.
ଯାଇଥିଲା 3 ମାସ କଣ ଲେଖନ୍ତୁ IA number so and so, this is an application for bail. It appears, may High Court record. It appears that as per the order dated 6/5/2024, the petitioner was granted bail, interim bail, for a period of
4 months.
4 months.
4 months.
4 months. 4 months. Learned counsel for the petitioner submits that after availing the interim bail period, he surrendered at right time. The surrender certificate has also been filed with the interim application. On the last date, we asked the land counsel for the state to obtain instruction regarding the conduct of the petition while on interim bail. Today, the land counsel for the state has produced the written instruction dated 11/9/25 received from the IAS in Nandipada police station to show that the petitioner was not involved in any crime during the interim bail period. And he has not flouted any terms and conditions. Stop. Considering the period of detention of petitioner in judicial custody and the fact that he has not misutilized the liberty granted to him by way of interim bail, we are inclined to release him on interim bail for a period of 3 months. Yes, next. This is taken on that purpose.
Item 47.
IA number 302 case. IA number 245 of 24 stay realization of fine allowed. Taki IA you have bailed up next week again. Next.
Item 48.
The appellant of sentence under section 302 of the Indian Penal Code will suffer rigorous imprisonment for life and to pay fine of 5,000 for commission of offence under section 302 I think in default of payment of fine to suffer further rigorous imprisonment for a period of 1 year. Yes. The total figures.
Eyewitness is there.
No one. Circumstantial
No,
evidence.
CW 12 with I.
No.
CW 12.
Is not an eyewitness.
Wait, let us see. CW 12 ना हो जी कौन अन्ना
Arun Kumar Bhuiya.
Arun Kumar Bhuiya. Purna the evidence na.
The informant is my elder uncle. I know this accused who is standing in the dock. The alleged incident took place in 2015. My uncle was
Having a tire repairing shop.
Tire repairing shop on Durga Prasad Market. The deceased is the younger brother of the informant. At the time of incident, I was
In his shop.
in his shop. While I was
Driving the bike.
And
this is was a pillion rider.
Pillion rider. This accused called my younger brother from behind. I left my uncle there and came to my uncle's house. After 5 to 10 minutes, my uncle shouted for help, and so I came back to the spot near the house of this accused. My uncle Krishna Naik also came to the spot and interfered from further assault of this accused. This accused immediately after assault by a knife fled away. We shifted the injured to SDH.
Bhanjanagar.
Bhanjapara.
Subdivision hospital.
So he came just
after the assault.
This is the pillion rider of the PW 12.
But he has not seen the assault. He
Not
reached
seen
the
the-
spot.
On hearing the shout, the accused called the deceased.
and
Deceased wait.
he saw the appellant was going away, fleeing away from the
Yes.
with the
That
knife.
after leading to discovery.
Knife was the weapon of offense. And what is the doctor who has
PW11.
11 is the doctor.
11 is the doctor.
The age of the injury is within 12 hours of the postmortem and the cause of death is shock.
କେତେ ନମ୍ବର ସାକ୍ଷୀ କେତେ ଯୋଉ 11
PW 11.
Exhibit से क्लियर किसी लिखना तो exhibit 5 is the PMT.
फाइव टा दरकार एग्जिबिट 5 टा inside wound over chest wall, left side, anterior axillary line, 10 cm below the nipple, clean cut margin, so and so breadth, deep penetrating injury involving pleural cavity, long and left ventricular of the heart. So it was antemortem in nature. Cause of death was shock arising out of massive intrathoracic hemorrhage of the left thoracic cavity, damage one of the corresponding injuries is there. How many years you are in custody?
Since 13, 12, 15.
13, 12, 15. Yes, 13, 12, 15.
9 years, 9 months.
And you are not released on bail during trial.
No.
Accused is produced in custody,
Page 4, judgment page 4, right?
That is big stuff. No वर्ष 6 मास age. Hard land counsel for the petitioner, land counsel for the state. The land counsel for the petitioner submit that the petitioner is in judicial custody for 9 years and 6 months, more than 9 years and 6 months. As he was taken into judicial custody on 13/12/2015, and he was never released on bail during trial or thereafter. He further submits that though prosecution case is that PW12 Arun Kumar Bhunia is an eyewitness to the occurrence, but from the evidence of PW12 it appears that by the time he arrived at the scene of the occurrence, the assault was already over. He further submits that there is no likelihood of the appeal being taken up in the near future for hearing, as it is Criminal Appeal of the year 2024, even though paperwork has been prepared, and therefore the bail application of the petitioner may be favorably considered. Land counsel for the state, on the other hand, submits that the evidence of PW12 indicates that he just reached at the scene of the occurrence when the accused, after assaulting the deceased, was going away with the weapon of offense, that is the knife, which was recovered at his instance. And
it will be 8 and 10 are 8 and 10 are witnesses.
8 and 10 are the witnesses to the seizure of the knife, and the doctor PW11 who conducted post-mortem examination has noticed injuries on the vital part of the body, like chest, and found the cause of death was shock arising out of massive intrathoracic hemorrhage. To the and left ventricle. Considering the submission made by counsel for the respective parties, By not inclining to release the petitioner on bail on merit but taking into account his period of detention in judicial custody and absence of any chance of hearing, we are inclined to release the petitioner on interim bail for 3 months. Yes, double date 15 next. What is it? What is it? What is it?
I think
कितना नंबर? कितना नंबर?
I think 37.
Just a minute. What is it? अच्छा मैडम आपण कौन अछंती बडबिल जेल रे
नमस्कार सर बडबिल जेल सर जेलर अछि सर
जेलर अछंती अच्छा
आज्ञा
ये जणे कन्विक्ट जहाकू आजीवन कारादंड हिची
आज्ञा
302 आईपीसी अनुଯାୟୀ ते एडिशनल
आज्ञा
सेशन जज चंपुआरे ट्रायल फेस करथिला ता ना होची राम अवतार राज बाहर तो तार पोजीशन कौन वर्तमान से
सर एक्चुअली से बडबिल जेल यूटीपी हिसाब रे थिला सर तापर ट्रांसफर हे सर से पळेई छि केउंझर जाइथिला
केबे कहि
आज्ञा
मैडम केबे कहि परिबे केबे गला केउंझर को
सर टिके सर सेटा आउ टिके पूर्व सर जानिथिले बाहर कर परथांती रेकॉर्ड मु तो देखि नथिले सर
अच्छा
किंतु से बर्तन नाम पाखरे नाही
अच्छा
डाटा नै छि सर से एक्सपर्ट करि जाई छि सर
केउंझर को जाई जंदी बोली आपण सियोर
सर केउंझर को जाई छि मु सर सियोर तापरे जति कि मु बुझिले तांका सुपरटेंडेंट को थारु से माने से अक्यूज जो माने से कन्विक्ट डेथ हे जाई छि सर एक्सपर्ट कर जाई छि
अच्छा ओके ठीक है केउंझर आपण इंस्ट्रक्शन नियो लेखन
आगे सर केउंझर सर जति डिटेल्स देबा कथा सर दे देबी पठे देबी टोटल केबे आसिला केबे जाइथिले
हां आपण पठांतु हम भी कहू छु सरकारी वकील ये मैटर टा पहर दिन आसीबो तो जदि डेथ ही जाइथिबो आपण भी रिपोर्ट दियंतु ता छडा सार मध्ये इंस्ट्रक्शन नेबे केउंझर जेल सुपरिटेंडेंट टू हला दियाडू आसु इंस्ट्रक्शन आसु लेखन
आगे सर आगे ठीक है सर
is the council is present? No, non-appeals like them. Since it's a jail criminal appeal of the year 2014, and we find that the prisoner's petition was received from Barbil jail, we instructed the land council for the state to ensure the appearance of the concerned jail superintendent and also the appellant if available in the said jail. Accordingly, Madam ko na likhi debe who is the jailer of Barbil jail appears to virtual mode and submits that she has instruction that the appellant was shifted from Barbil jail to Kendrapada jail. Sorry, Keonjhar jail. And if the matter is taken off day after tomorrow, she can state about the well-being of the said appellant. Put up this matter day after tomorrow. The Land Council for the state shall obtain instruction regarding the well-being of the. I mean, she is not also CO, but just obtain the instruction. And if death is in writing so that it can be disposed of. Day after tomorrow. Personal appearance dispense with program. The madam pro na take in the jail or আমি যে তিনটা ম্যাটার করছিল সবটা তো অ্যাপিয়ারেন্স হয়ে গেল। হ্যাঁ ঠিক আছে। Next.
Item 49.
Please, your lordship. I'm there virtually.
Yes, Mr. Panda.
Your lordship had directed the state to take instructions as to the whereabouts of the children of the appellant on the
I have
last.
an instruction, my lord.
Three children, two sons and one daughter,
Aye.
was deposed to by PW9 Ogadi Sahoo, the mother of the appellant.
Aye.
एगारो वर्ष 7 वर्ष 4 वर्ष अच्छा
PUC प्रकार ରହୁଛନ୍ତି
हाँ
PUC ପ୍ରକାର ରହୁଛନ୍ତି
अच्छा
ଆଉ
they were also prosecuting their studies.
Yes.
It appears.
and grandfather Vipra Sahu is maintaining some expenditure.
They're getting good livelihoods in their own service. Grandfather is Vipra Sahu is filing their expenditure, who is running a pesticide shop in village Jura.
And can I have a glance to the evidence of PW9, who is the mother of the accused. I am the mother of the accused, Narayan Sahu. The deceased Jayanti Sahu is the wife of Narayan Sahu. They have been blessed with 3 children, that is 2 sons and 1 daughter. Jayanti Sahu died in 1 year 20 days back. 1 year 20 days back. My son Narayan Sahu always assault me, my another son, my husband, also his wife and children, for which I, along with my husband and another son, have been residing separately from him. My daughter-in-law was a good woman. My son always threatened to kill. We also took my daughter-in-law, Jayanti Sahu, and her children with us and keep them for 2 months. 2 sons of Narayan Sahu were living with my daughter at Ankushpur. ଏବେ ବି ସେଠି ରହୁଛନ୍ତି. And the daughter was living with me with her mother. After 2 months, in absence of my husband and another son, Narayan Sahu came to my house and forcibly took his wife Jayanti with him. During stay of Jayanti Sahu with Narayan Sahu, he asked her to bring cash of 50,000, either from me or from her mother. And when Jayanti Sahu did not agree, for which Narayan Sahu assaulted her regularly. At last, in the next day of Dhanu Sankranti, in the month of Pausha, my son Narayan Sahu has committed murder of my daughter-in-law Jayanti Sahu by pressing her neck. My son Narayan Sahu is not a good person.
He is in custody since 2022.
Madam.
19/12/2022. The day after the
conduct in jail, you obtained that also. Aggressive nature.
Aggressive nature, and if the petitioner released on bail, it will be a threat to the family member, those who are maintaining the children.
With due respect, my lords, these assumptions are without any substance.
No, it has substance.
No,
Because of the
my
statement of
submission
the-
is this, my lords. I may be a violent person. I may have assaulted my wife and my children, but where is the evidence of murder?
We'll see.
Yes,
that.
to
How
Dr.
could I be convicted under 302 on the basis of hearsay evidence?
307 is the doctor, cause of the homicide.
And my learned friend is making
The
submissions
Council for
as
the
though
state has produced the
this lady is an eyewitness.
report of the IIC Patapur Police Station dated 15/9/25, which indicates that the 3 children of the petitioner are now staying in the house of their aunt, and the grandfather is maintaining them. The report is let the Land and Council for the state obtain instructions regarding the criminal antecedent, if any, against the petitioner, so also his conduct inside jail, put up this matter on such and such date. Yes, next.
Item 50.
May please your lordships. My lords had directed me to file an affidavit with regard to the antecedents. And I have filed an affidavit, my lords, in the case herein, my lords, he's been acquitted in the meanwhile. In the two cases, he is alleged to have been implicated. My lords will find the affidavit at flag E.
The state produced that instruction.
Okay.
That
State has produced it.
from IAC Sahid Nagar Police Station, that there are two other cases apart from this case.
My lords.
So what are those two cases?
Given the details, my lord, flag E.
Flag E.
E, my lords. I filed the affidavit.
Okay.
Without any copy not attached, only in through.
Copy has not been attached.
No, but he says affidavit.
Yes, that was sent to the IAC on 30th August.
This is from e-courts, my lords. I've written that as well.
And 379 only.
Fine.
And what about this case? What is the?
This is 302, my lord.
Yeah, what is the?
There is a direct evidence. PW1, who is the doctor, is the direct. She's the direct witness to the occurrence.
Doctor is a direct witness.
The daughter, Jia.
Doctor.
The accused is the husband. The deceased was the wife, and the occurrence took place, my lords, on 29/2022.
Evidence.
On pardon me.
No evidence.
PW1 is just fall short of 5 years, my lords.
PW1 and PW4 arrived.
PW1, he states that she was aged about 20 years.
My lords.
What she has stated?
She stated, my lords, 1, 2, 3.
Come to PW1.
My lords, PW1, 6th line from the top. The
Ah.
first page itself. On 2020, at about 10 p.m., my father quarreled with my mother and stabbed her under the chest inside our house. My lords, found it?
Yeah.
At that time, myself, my younger sister, namely Amrita Mukhi, Aradhya Mukhi, and Sunita Mukhi, were present. Due to the stab, my mother suspected.
Doctor's evidence.
My lords, the deceased was first initially examined, which is PW7. She was only treated as an outdoor patient, and my lords will see the injury at page 60, if my lords is seeing. PW7, the first paragraph itself.
The doctor is you conducted PM is
PW8, my lords, but I am referring to PW7 first, who was immediately an assault, which he has examined. PW7, first paragraph itself, my lord, fifth line from the bottom. I found during treatment one incised wound on the left side chest, size 1 inch into 1.5 inch into 1.5 inch, and I referred the injury to the surgery specialist for further treatment, etc. And on the same day, she was released when she was discharged as an outdoor patient, my lords. Now, my lords may kindly turn to page to the PW8. PW8, my lords, there are two injuries. In the PM, 2 injuries have turned out. The first one is bruise over the left breast, lower outer quadrant of 4 centimeter into 4 centimeter, looking yellowish green in color. And the next one is stitched wound, size 2 centimeter over 3 centimeter below lower angle of scapula. On opening, it is like 2 into 205 cm chest cavity. So, my lords, this is the basic case that there are.
So when the deceased actually died?
My lords, the incident occurred on 29/2020, 20th of September 2020. The death she was then taken to treatment, and on 26th, she was as an outdoor. After that, on 26th line, the condition deteriorated. 27th, she was taken to SCB Medical, and 28th, she.
So what is your submission? You assaulted your wife?
My lords, I have
by means of a knife.
And she's also stayed for less than 5 years, just short of 5 years, my lord. Just about 10 days or 20 days short. I pray let it come after puja. And after that, it will be a better case.
But by the way, Mr. You obtained the jail conduct in the meantime.
My lord, I have obtained custody certificate Real conduct act.
Custody certificate ଆଣିଛନ୍ତି?
Yes, sir.
You produce it?
Yes, sir.
The land council for the state produce the custody certificate. However, he seeks some time to produce the jail conduct. ବାକି
Custody
ଏଇଟା ତ
certificate already filed.
ଓ ଫାଇଲ୍ କରିଦେନ୍ତି ତାହେଲେ ଛାଡ଼ନ୍ତୁ କାଟି ଦେଇଛନ୍ତି ଜେଲ୍ କଣ୍ଡକ୍ଟଟା ପାଇଁ ଖାଲି ରଖିଦିଅନ୍ତୁ ଇଏ ପରେ ହେଲା ବାକି ଏଗୁଡ଼ାକ ସବୁ ରଖିଦିଅନ୍ତି ପହରଦିନ ପାଇଁ